All right. Good morning, everybody. My name is Dana Sparks, and I am the director of the Georgia Real Estate Academy, which is the school offering this class for CE credit. We are going to get started. This class is the 2022 GAR, Georgia Association of Realtors Contract Dissection course. It is GREC course number 73594 through the Georgia Real Estate Academy, which is GREC School 6915. There are handouts available, but you do not need them for this class. They are there for your reference after class, or if you want to follow along. But everything you need for this class will be presented to you through a PowerPoint presentation and through the screen. So if you have any questions, please type them in the chat, and I will monitor those as we go along. So let me share my screen. Welcome, everybody. All right, and we are going to get started. If I can find where slideshow is. Slideshow from beginning. All right, everybody, here we go. Again, my name is Dana Sparks. I am the director of the Georgia Real Estate Academy, which again is the school offering this course for CE credit. I am also the qualifying broker of Maximum One Greater Atlanta Realtors. The only reason I tell you that is because this is a contracts class, and I still am involved in the contracts on a day-to-day basis. I don't see every contract. We have a compliance broker that reviews every single contract. I just see the contracts that have issues. So, one or two a year, right? But I am what is considered a quote unquote non-competing broker, meaning I do not actively interact, list, or sell anymore. I don't interact with buyers and sellers other than from a management broker point of view. I just manage the company, help out agents, and teach classes and deal with co-op agents and co-op brokers. But I just wanted to give you a little bit of background that I am still seeing the issues that agents out in the field are currently dealing with, and we will address some of those issues as we go through the contract. Notice per students per GREC, this is an approved classroom class for classroom presentation or virtual broadcast. Again, through GREC School 6915. It is the 2022 GAR Contract Dissection GREC course number 73594. This is a virtual or remote broadcast of an approved in-class course, 3 hours in duration, approved by GREC for CE credit. You may only, for any virtual class, you may only take one virtual CE class at a time or with overlapping times, regardless of the school offering the course in order to get CE credit. In other words, you cannot have two computers open and try to pay attention to two CE classes at once, or you will not get credit for either course. I am your instructor. No required homework, no written exam. You must be on time and present for all remote virtual broadcast instruction hours in order to receive credit. Roll call and documentation of your license number is conducted via the chat function. Again, as I've already mentioned at the beginning and end of each session and after all breaks. You may only receive credit for a specific course number once every 12 months. That's not on a course topic. It's just on a specific course number. In other words, you can take 5 classes on the 2022 GAR contract. As long as they are separate course numbers, you will get CE credit for all of those. No recruiting for employment opportunities for any real estate brokerage firm is allowed in this class or on school premises. Report promptly any effort to recruit on behalf of a brokerage firm by anyone, including a fellow student, to myself. or Heidi Kelly, who is the coordinator of the Georgia Real Estate Academy, or directly to GREC. All right, we are going to dive in. I am going to let you guys know we could spend all year, months and months and months on just the purchase and sale agreement alone. The purpose of this class is to cover the GAR, Georgia Association of Realtors contract, and some of the main forms that you are going to use in contracts, especially the financing contingency forms. This is not a contracts 101 class. I'm not going to cover how to fill in the blanks. Our school, the Georgia Real Estate Academy, offers a variety of classes for further information, including contracts offer and acceptance, which is basically a contracts 101 class. It goes through the contract line by line, how to fill in the blanks, those kinds of things. We teach another class called GAR Real Estate Brokerages, Exhibits, Amendments, and Special Stipulations, where we cover the brokerage agreements and a lot of the amendments and exhibits more in depth. We cover the RE forms contract classes. We have another class called 2022 Contracts Review, where we compare and contrast the GAR contracts versus the RE forms. So there are a variety of other classes to learn more information. The purpose of this class is just to go over, to dissect, so to speak, the GAR contract from a point of view of content and what you need to know to protect you and to protect your clients and customers and your broker. So I am going to teach this at a level as if my audience were experienced agents. And I do see a lot of you on here are old friends and are experienced agents. Again, if you have questions, please type them in the chat and I will get to them. And I will stay as long as we need after class. All right, here we go. There is a lot to cover, so we are just going to dive in. GAR, the Georgia Association of Realtors, makes changes to their contract packages based on what's going on the market and agents and their practice and the suggestions and issues and questions they bring to GAR. They make changes at the beginning of every year, and then they always do a mid-year review. Usually their mid-year review is a correction of things like typographical errors, grammatical errors, syntax, order, things like that. Every now and then they will do some pretty substantial content changes throughout the year, and they publish those mid-year around March or April. Last year they made them April 15th. I have not quite seen the contract changes yet for mid-year review, but look forward to them. As a hint, wherever it is that you as an agent go to get your contract forms, whether it be through Remind Docs or Transaction Desk or Dot Loop or wherever it is that you access your contract forms, I suggest around now, April, May, you go in there and GAR does publish an index of the changes that they made mid-year review. So that's just a good idea to go and check that out and review the changes they make. GAR makes universal changes that apply across all forms, and you have to be licensed to use the GAR forms. You are licensed either if you are a realtor, then part of your dues money goes to GAR and you have access to use the forms for that year, or you can pay GAR directly. GAR forms may not be given to the public to use, and you may not use another agent's forms if you are not an authorized user. GAR's intent is to keep transactions together. There is a legal helpline. If you are a realtor, you just enter in your NRDS number. You can get this if you Google Georgia Association of Realtors or go to garealtor.com. And there is a legal helpline where you can ask a question. All right, general contract reminders, regardless of whatever contract form you are using to help your clients and customers buy or sell property. A legal description is required. In Georgia, a street address is not sufficient information. Just think to yourself, how many Peachtree roads are there? More than one, right? Therefore, there could be more than 123 Peachtree Road. Therefore, especially in Metro Georgia, Metro Atlanta area, you are going to need a legal description. Per license law, parties must get a copy of everything they sign. Please make sure your brokers also get a copy, and your lenders and closing attorneys are going to need copies. Make sure they get copies of all amendments to prevent any delays at closing. Don't leave any blanks. You are either going to use NA for not applicable, or if the fill in the blank is preceded by a $sign, it calls for numerals, not words. So you're going to put in 0 or an amount. Or if you are filling in a counter offer, and let's say the only thing being let's say the price is not being countered, it's just the closing date, for example. Well, you're not going to put in NA in the price because obviously the sale price is applicable. You're going to put NC, which stands for no change. In other words, on the counteroffer form, the price is not changed from the original offer. Do not use TBD or to be determined. That does not reflect a meeting of the minds, which is required for enforceability of contracts for real property in Georgia. If a contract is subject to financing, all of the terms on those financing exhibits must be completed per license law. If you are an agent, do not hold earnest money. Per license law, you must get earnest money to the broker as soon after receipt as practically possible, or whomever the holder is. Complete your brokerage address on the signature page. There is no GREC license laws regarding an address. So on the signature page, it can be either a branch office if your brokerage has more than one branch, or a corporate address. But please make sure that the address is filled in on the signature page of your purchase and sale agreements for a variety of reasons. Number one, for notice purposes for your broker. And number two, sometimes closing attorneys will need to send either a commission check or a copy of the settlement statement to the broker, and they will need a physical address to send it to. Per license law, on any contract, whether it be GAR or whatever form, you need to complete in your personal real estate license number and the firm license number of the brokerage that holds your license. Also, per license law, y'all need to complete in the agency representation in the contract. There are fill in the blanks for that on the GAR contract. But again, if you are an agent and you are working with, let's say, a HUD contract or new construction contract, there may not be a fill in the blank place for the agency representation, but per license law, that needs to be in the contract. So you will have to add that in there. Regardless of who the holder is for the earnest money, and regardless of which side of the contract you're on, if you're representing the buyer or the seller side, you have got to follow up with the earnest money deposit. Follow up with the holder. Did you receive the earnest money? Did you deposit the earnest money? Did you receive the earnest money? Did you deposit it? A picture of an earnest money check is not proof of anything. I can write a check right now for $1 million and take a picture of it and send it. That has nothing to do with anything. It doesn't mean I sent it to a holder, and it certainly doesn't mean that the holder deposited it or that it did not bounce from the bank. So really, to protect yourself as an agent, to protect your broker, and to protect your clients, you need proof of deposit, not just a picture of a check. All buyer and seller signatures are required, and don't miss any initial spaces. And if you are working with a customer rather than a client, on the purchase and sale agreement itself, you will need contact information for a customer. That would be either and you'll see later when we get the contract on notices, that will be either an email address, a fax number, or a physical address. If you are working with a public person as a client, then your contact information suffices, but for a customer, we will need their contact information. Now, as a broker, if you are working with a public person as a client, then you will have already completed, the client will have already completed either the seller brokerage agreement or the buyer brokerage agreement. Please, please, please make sure that you fill in contact information for your public person on the brokerage agreement, a phone number, an email address, and a physical address so that your broker has it should you not be available and your broker needs to get in touch with that person. Continuing on with general contract reminders, please limit the use of special stipulations. You definitely want to check with the pre-printed special stipulations available from the Georgia Association of Realtors in their special stipulations library, or also check with the special stipulations library for the RE forms contract package, which is also available wherever it is that you access your contract forms through, for example, Remind Docs, Transaction Desk, Loop, so forth and so on. The RE forms, some agents refer to them as the FMLS forms. Those contract forms are available for no cost to all real estate agents in the state of Georgia. And they have some additional special stipulations that you might find useful in your contract. Do not write or use a special stipulation for an issue that is already addressed elsewhere in the contract. And when we get to the contract, I'll tell you why that is extremely important. And additionally, you probably would want to consult with your broker or an attorney before writing any special stipulation on your own. Again, please check out the GAR library for other useful forms and special stipulations. As I already mentioned, we have other pertinent classes that you might find informational, hopefully. 2022 GAR contract changes, that covers the changes that GAR made from 2021. The comparison and contrast of the Georgia Association of Realtors forms versus the RE forms, the RE forms contract dissection, brokerage agreements, other useful forms, and so forth and so on. All right, we are going to cover purchase and sale agreement, counter offer, financing contingencies, community association disclosure, closing attorney as holder of earnest money, agreement of closing attorney to be the earnest money, amendment to address concerns, unilateral notice to extend, TNR agreements. We're going to cover notes about earnest money and consumer brochures. And I have some additional special stipulations. Now, we're getting ready to dive in. I have one question. How do you reach out to GAR for the forms? If you Google Georgia Association of Realtors or you go to garealtor.com, you will find the information there about how to pay for the Georgia Association of Realtors forms. You will pay GAR. You will get what's called an FPID or Forms Purchase ID number. Then you get with your MLS service, and they will walk you through how to enter in that Forms Purchase ID number into your MLS access. And then when you go into wherever it is you access your forms, the GAR forms packages will auto-populate. All right. In the purchase and sale agreement, paragraph A is all the fill in the blanks. All right. I am going to do this a couple of ways, and I hope I'm not going to make you dizzy. But I have, and these again are available for you after class, but I am going to show you. Let me get rid of that. One of the handouts also is a printout of all these slides. But here we go. This is the purchase and sale agreement, and I have everything underlined that we are going to address. So how I'm going to do this class is I'm going to show you guys what it looks like actually on the form and cover what needs to be covered. So again, I hope I don't make you dizzy, but I find that this hopefully will make a little bit more sense. So all the fill in the blanks are on page 1. And then here I have it says pages 1 through 8. Therefore, all pages must be included when sending, not just the signature page. So here is what I mean by that. See here at the bottom, oops. See where it says F201, purchase and sale agreement, pages 1 of 8. If you are working with another agent and you are sending these forms, obviously there's a lot of e-sign programs, electronic signature programs through Remind Docs, through Transaction Desk, through DocuSign, through Dotloop, through SkySlope, through Paperless Pipeline. There are a variety of ways to do that. But another method that a lot of agents will do is just send a contract as an attachment to an email. If you are doing that, if you are sending a document and the document says pages 1 of 8, make sure to include all 8 pages. Don't just send, for example, a signature page. If you are the recipient of an attachment and it has a number of pages, make sure that the attachment includes all of the pages to protect yourself and your clients so that nobody can change any of the intermediary pages and just send you, for example, a signature page. Again, as I mentioned, a legal description is required. When it says attached, that typically would be a copy of a seller's actual warranty deed. If you are filling out land lot, district, section, block, so forth and so on, plat book, page, subdivision, if you do not have all of this information, that's not going to be the best legal description. It would be better to fill out the deed book and page number. And that's the warranty deed book, not the plat book. Again, purchase price, seller's contribution, and closing costs. Now for closing date, this needs to be a specific date. Do not put on or before. For example, do not put on or before April 20th, 2022. That does not demonstrate a meeting of the minds. And if for those of you that have been practicing for a while, you'll remember GAR used to have that verbiage. It used to say closing shall be on or before. They took it out. They took it out for that reason. And here's an example of what you can always change it by amendment. But here's an example of why that does not demonstrate a meeting of the minds. Let's say a buyer and a seller go under contract and the contract says purchase and transaction to be closed on or before, let's just say on or before April 15th. Well, let's just make it later. Let's say to be closed on or before April 29th. And let's say that the buyer's lender gets everything done and they're ready to close April 20th. But the seller has, they don't have anywhere to go until the 29th. They've got moving trucks scheduled for the 29th. They've got their utilities scheduled for the 29th, so forth and so on. Well, the buyer's broker calls the seller's broker and says, hey, guess what? Great news. The lender got everything ready and we've rescheduled closing. We are closing on April 20th. And the seller says, April 20th, I don't agree. I agreed to April 29th. And the buyer's agent says, well, you already did agree. You agreed to on or before April 29th. And guess what? April 20th is before April 29th. So you potentially have a huge mess on your hands. So do not put in on or before. GAR took it out. Do not add it back in. Then you're going to name the closing attorney firm and their phone number. The holder of the earnest money, that should be a brokerage, or if for whatever reason a lot of buyers and sellers are opting to have a closing attorney hold the earnest money, I'm not sure why. I do know why, but I'm not going to get into that here. But if you do elect a closing attorney as the holder of the earnest money, here is a reminder to you. GAR F510 must be attached as an exhibit, and then later F511 must be signed by the closing attorney. Let me see if I have those now. Yep. Nope. Let's go ahead and cover that. Yeah, you know what? Let's go ahead and cover that now. Let me see if I have them. I should have them. Let me find them. There we go. All right. So if the buyer and seller choose to have a closing attorney as the holder of the earnest money, this form, this is GAR F510. This must be attached as an exhibit. And this is, it's a description. It says, after the buyer and seller go binding, the buyer is responsible for delivering the binding contract to the closing attorney within 2 business days from the binding agreement date. Then the closing attorney must agree to sign agree to be the holder of the earnest money within 3 business days thereafter. And they have to sign a form, which I'll cover in a second. Additionally, the closing attorney, once they agree to it, agrees to perform all the services of holder, all the duties and obligations as the holder of the earnest money as expressed in the contract. The earnest money must be paid to the closing attorney as holder by wire transfer, or any other method deemed acceptable by the closing attorney. Now, if the closing attorney does not agree in writing to be the holder within that time frame, then you must name an alternate holder, and that party becomes the holder of the earnest money. And it says in here, the alternate holder must be either the buyer's broker or the seller's broker. And if for what a lot of agents leave that blank, if you leave it blank, it automatically becomes the buyer's broker. If this is really, really important, you guys, if the deal is an all cash transaction and the contract fails to close and there is a dispute, so you don't close and one of the parties sends a TNR, the other party does not agree on the disbursement of the earnest money. If it is an all cash transaction, the only thing a closing attorney as the holder of the earnest money can do is interplead the earnest money into the court. In other words, you now have engaged the buyer and seller in a lawsuit over the earnest money. That incurs court costs and legal fees that come out of the earnest money. And a judge can rule if the parties, one or both of the parties hires an attorney, the judge can rule that the loser not only loses the earnest money, but also has to pay the winner's attorney's fees. So all cash transaction, y'all make sure to have a conversation with your buyers and sellers to make sure if you want the closing attorney to hold the earnest money. If one of the brokers is holding the earnest money, it's an all cash transaction. The broker does have the opportunity to make an interpretation of the contract and disperse the earnest money based on a contract interpretation. What if neither company holds the earnest money? Who would be the alternate holder? It says right here, it has to be either the buyer's broker or the seller's broker. If the closing attorney does not agree to hold the earnest money, it must be one of the brokers involved in the deal, and if none is named, it automatically becomes the buyer's broker. And then you need the party's initials. Again, this is an exhibit, so only the buyer and seller initial. So at this point, everybody is saying, okay, we want such and such closing attorney to be the holder of the earnest money. Well, the closing attorney has not agreed to that. There are a lot of times a closing attorney will not agree to hold the earnest money. Number one, they might have a conflict of interest. They might have a client relationship with one of the parties. The earnest money might not be an amount where they agree to hold it. It might be that the closing attorney won't agree to hold the earnest money until they receive the earnest money. So this is an exhibit, but we still don't have the closing attorney holding the earnest money. This form, this is GAR form F511. This you'll see, it doesn't say agree, it doesn't say exhibit anywhere in it. It says agreement of the closing attorney to serve as the holder of the earnest money. And again, you need to check with your closing attorneys to see if they're going to hold the earnest money. They have to sign this within 3 business days of the receiving it. Remember, the buyer has 2 business days to get this document to the closing attorney as holder, and the closing attorney has 3 business days to sign it. If they don't agree, and it says sign this without modification. If they don't agree, then the alternate holder automatically becomes the holder of the earnest money. And you'll see you need to fill in all the contact information for the parties. But this is only signed by the closing attorney. This is not an exhibit to your contract. Buyers and sellers don't sign this. It's only signed by the closing attorney or the representative. And it is signed after the buyer and seller are binding on a contract and have already identified a closing attorney to hold the earnest money on that exhibit GAR F510. All right. There are some closing attorneys that are very well versed in the contracts, and should there be an issue, if there is a loan involved, can interpret the contract to disperse the earnest money. There are other closing attorneys that are not well versed in the contracts. They're fabulous closing attorneys, but not as well versed in the contracts as your brokers are. And a lot of times the clients will think, well, the closing attorney is a third party, sort of neutral party, and should be a better, more neutral holder of the earnest money. You guys, your closing attorneys have relationships with various agents, with various brokers, and they represent the lender who is hired by the buyer if there is a loan involved. So even if a broker is holding the earnest money, if there is a dispute over the disbursement of the earnest money, at that point, the broker has to take off their broker-client relationship hat and put on their neutral third party, I've been entrusted with this earnest money, and interpret the contract to determine what happened, why it failed to close. Your brokers can lose their real estate licenses. Their real estate licenses can be sanctioned, and their company can lose the real estate license if they disperse earnest money contrary to the terms of a contract. Your closing attorneys, they obviously can't do anything illegal with the money, but they are not bound by real estate license law because they don't hold a real estate license. So lots of discussion regarding who is going to hold the earnest money. All right. Then continuing on with earnest money, you fill in, you determine if the earnest money is going to be paid by check, ACH, cash, or wire transfer, and either the amount. This option A, you only fill in if you are or the holder is in possession of the earnest money at the time you're writing the offer, or so many days, the amount in so many days from binding agreement date. Just a note, if the earnest money is going to be wired from the buyer to the holder, due to a lot of wire fraud issues in our industry right now, the majority of brokers and closing attorneys are only sending wire instructions via US mail. They are not coming by email, even with encrypted emails. A lot of attorneys are no longer even using encrypted emails to send wire instructions. Therefore, if the earnest money is going to be wired, y'all need to account for that and add in a longer number of days from binding agreement. In other words, I wouldn't put 2 or 3, I would put more like 5 or 7 to account for the wire instructions to get mailed via US mail from the holder to your client, and then your client to act on that. Point of practice for you agents, y'all can go physically pick up the wire instructions from your broker, from a closing attorney, and have them with you. And then when you are meeting with your buyers in person, hand them the physical paper that has the wire instructions on there. And then prior to the buyer wiring earnest money to the holder, just confirm them. But that would limit the number of days from the binding contract to wire the earnest money. All right. Again, per the purchase in, per the PowerPoint, we talked about that. Now, a couple of other things for point of practice for you guys to consider when dealing with earnest money. Number one, whomever the holder is, you're going to want to check on their policies regarding the form of funds. So just because a buyer and seller agree that the earnest money can be in the form of a check, if the holder will only accept a personal check up to a certain amount of money, you're going to want to know that prior to buyer and seller agreeing to that. For example, a lot of brokers and closing attorneys will not accept a personal check for anything over $5,000. If it is a personal check, a lot of them will hold a personal check for up to 10 banking days. A lot of holders will only accept certified funds, will not accept an electronic transfer of funds via, Cash App or Zelle or PayPal or Venmo. Will not accept an ACH. Some will only accept a wire. A lot of closing attorneys and brokers will only accept earnest money over $10,000 in the form of a wire. So you need to check with the holder on their policies regarding the form of funds. Point of practice, you guys, you should only deal with certified funds or wires for earnest money. Number one, a holder may act on that more promptly. And number two, generally speaking, it is more secure. Also, if the earnest money is over $10,000, I strongly suggest that those funds be sent as a wire. The reason is, per the Homeland Security Act, if anyone is holding money on behalf of another, i.e. earnest money, security deposit, so forth and so on, over $10,000, if it is not in the form of a wire, there is an IRS tax form, IRS form 8300, that must be completed, which has a lot of identity information from the person giving the earnest money that a lot of your buyers are not going to want to fill out, but the holder cannot hold it without that tax form. If it is in the form of a wire, the Homeland Security Act, the IRS, does not require that form. All right. Additionally, y'all be we talked about that. Y'all be really careful. Do not accept cash as earnest money. Do not accept cash as earnest money. Do not accept cash as earnest money. Don't commingle funds. If the buyer only has cash, don't say, okay, well, send me the cash and then I'll change it to a certified check or send it via digital app, so forth and so on. That is commingling funds, and that is a license law violation. Be very, very leery of sending earnest money as an ACH payment. A lot of closing attorneys and a lot of brokers will not accept an ACH payment. That's when it electronically comes out of a person's checking account electronically. It stands for Automated Clearinghouse. And the reason that that's not such a great way of sending funds, it is not secure. An ACH payment can be reversed by the holder up to, I believe, 6 months, and by the bank. So even though buyer and seller might agree to that on a contract, please check with the policies of the holder of the earnest money. If the buyer is remitting, which is just a fancy word for send, if the buyer is sending the earnest money funds to the holder directly, make sure that your buyer puts a note. If they're sending it via US mail or dropping it off, make sure they put a note with the property address of the property they are purchasing and the agent's name. I can't tell you how many times we received a check for thousands and thousands and thousands of dollars made payable to the brokerage, and it has no identifying information other than the person writing the check's name. If it is a personal check, then it might have an address in the upper left corner, but that's the address of where they currently live, not where they are buying. And a lot of brokers keep track of transactions via the property address, not the parties' names. If it's a certified check, a lot of times it'll just be payable to the brokerage for thousands and thousands of dollars. And in the memo section, it'll say earnest money. Your brokers or your closing attorneys have no idea where to attribute those funds to if there is not an identifying information regarding the property they're buying or your name, so the holder can contact you and find out what property this goes to. Again, as I mentioned, if the earnest money is over $10,000, very best to send via wire. And when you are considering earnest money, should the buyer default on the contract, the GAR contract says that the only remedy for the seller is the earnest money as liquidated damages. It's not required for a binding contract for the buyer and seller, but it is liquidated damages should the buyer default. Again, as I've mentioned, it is your responsibility to follow up with the holder. Did you receive the earnest money and did you deposit it? Because both buyer and seller do have contractual rights to those funds, especially should something go haywire. So you're going to want to know if it is actually in the possession, meaning deposited and not bounced from the bank. Talked about that. All right, now let me go back. Let's look at the contract itself and let's see if we're up to the next section. All right, here we go. Perfect. We are now going to talk about inspection and due diligence and what that is all about. A due diligence period merely creates an option for the buyer to terminate the contract for any or no reason within the certain number of days here. So it states due diligence period, properties being sold subject to diligence period, a blank number of days from binding agreement. I know we are in, this is April 2022, and we are in an extremely, what we call a fast market. There is less inventory than there are buyers out there. So a lot of sellers are getting multiple offers. A lot of buyers are doing whatever they can to make their offer more attractive to a seller in a competitive situation. One of those things is to limit the number of contingencies or put in 0 contingencies. One of the strategies is to put in 0 days due diligence. I highly, highly, highly encourage you to at least put in 1 day of due diligence. Due to the market, there are a lot of buyers. It gets extremely emotional for a buyer, especially if they have lost out on a number of contracts. They finally get one. They want to make their contract more attractive to a seller. So they'll put in 0 days due diligence. They go under contract. They're all excited. They go to bed at night. They sleep on it, and they wake up in the morning and they're like, oh my gosh, what have we done? We just got carried away with everything. We really do not want, excuse me, we do not want this house. If they terminate at that point, they will lose their earnest money. They will be in default of the contract. So again, I strongly, strongly encourage you guys to at least put 1 day due diligence to give your buyer the right to sleep on it. A seller is not going to be out anything if a buyer terminates within 1 day, especially if it was a multiple offer situation. They will have another offer where they can go back to. So, like I said, a due diligence period basically creates a mini option contract within the broader context of the purchase and sale agreement. So a buyer has termination rights within the due diligence period. A seller does not have termination rights within a due diligence period. It is only an option for the buyer. So there are a lot of things that a buyer will do to help them make the decision if they're going to terminate the contract or go on with it. Before I get to there, let me comment just a little bit on this second section where it says right here, paragraph 8B2, additional option money. So because the due diligence period creates a mini option contract within the broader context of the purchase and sale agreement, there has to be what's called consideration for a contract to be enforceable. So you'll see here in paragraph 8B, option payment for due diligence period. In consideration, that's just a legal term for enforceability of the due diligence period. It says, in consideration of the seller granting the buyer the option to terminate. Number one, the buyer has paid the seller $10 in non-refundable option money, the receipt and sufficiency of which is hereby acknowledged. That $10 never changes hands. That is just legalese for the due diligence period to create a mini option contract. This second section, it says buyer, it says plus buyer shall pay directly to seller additional option money of blank amount of dollars. This is additional to this $10. This money is not earnest money. It is a complete separate pile of money from earnest money. It is not protected. It goes directly from the buyer to the seller, and it is non-refundable. I don't have it underlined, but the very last paragraph here, very last sentence says, either the buyer and seller negotiate if it shall or shall not be applied towards the purchase price, but it is non-refundable for any reason unless the seller defaults. But good luck getting it back from the seller. This additional money, this option money, does not go to the holder, does not get handled by you. It goes directly from the buyer to the seller. We very, very, very rarely see this filled out. Usually this is zero because, again, it's not earnest money. It's addition to this $10. In this market, however, we have been seeing this option used a little bit more, again, as a buyer strategy to entice a seller to pick their contract over a competing contract in a multiple offer situation. Non-refundable money. It's extra money for the seller that's non-refundable unless the seller defaults, may or may not be applied as a credit to the buyer at closing. You buyer's agents, if you are if your buyer is writing an offer on a property and it is not a multiple offer situation, do not risk your buyer's additional money to go to the seller because it is completely non-refundable. There is no protection for this money unless the seller defaults. But I just wanted to bring that to your attention because, again, based on this market, it is a strategy a lot of buyers are using. But back to the due diligence period in and of itself, again, it's an option for the buyer that the seller gives the buyer the option to terminate for any or no reason. So there's lots and lots of things a buyer's going to do to help them figure out, am I going to terminate and protect my earnest money, or am I going to go through with the contract? They can have a home inspection done. They can check out the roof. They can have a survey done. They can check out the commute to school. They can check out the zoning of the property. They can make sure it's in the correct school district. They can make sure they're getting their job. They're keeping their job. They can make sure their loan is going to go through. They can make sure there's no flood insurance that's going to be required. They can check out the HOA covenants. They can make sure they like the property. They can use Google Earth and Google the property and see if there is a nuclear power plant that is behind the cedar cypress trees that you can't see. They can check the sex offenders list and make sure there's no sex offenders living next door. There's a lot of things that a buyer needs to investigate to figure out if they're going to terminate or not. This is the time frame to do it. If a buyer chooses to terminate the contract, they send a TNR, and the reason is they just terminate, the reason would be per their due diligence period. You do not need to give any more specific reason other than that. A buyer may have a due diligence period, even if the seller is selling it as is. A buyer still has the opportunity to check out a house, have it inspected, have the structural foundation inspected, check for radon, check for mold, check for asbestos, check for lead-based paint. As is simply means the seller is initially saying they are not going to do any repairs, but that does not prevent a buyer from checking out the property. And Georgia is a caveat emptor state, which means the contractual burden is on the buyer to make sure that they are satisfied with whatever they are purchasing prior to exchanging money for that thing. So in the instance of real property, the legal burden in Georgia is on the buyer to check it out before they go through with the deal. The seller, per Georgia law, is only required to disclose latent material defects. And a latent material defect is, number one, something that the seller has knowledge of, and number two is a material defect of the property that cannot be determined by the buyer via reasonable inspection. In other words, if the floor is covered by an area rug, if it's a hardwood floor covered by an area rug that's damaged, if a buyer picks up that area rug and can see it, that is not considered a latent material defect. If there is a stain on the drywall that is evidence of a prior leak, if the buyer can see that stain, that is not considered a latent material defect that the seller must disclose per the Georgia fraud laws, because a buyer can see it via a reasonable inspection. So y'all be really careful. Again, due diligence period is for the buyer to check out everything. All right, here is everything that I just covered on that. All right. Moving on, let's check out the contract. Next section is, again, lead-based paint. Again, if the property was built prior to 1978, you must include a lead-based paint disclosure exhibit, and the buyer must get a copy of the lead-based paint pamphlet, which is available through the GAR forms, or you can go to the EPA and download both of those. And brokerage relationships, again, per license law, you must disclose an agency relationship. So you would put the brokerage firm, and you put is representing the buyer as a client, customer, dual agent, designated agent, seller, brokerage firm representing the seller, client, customer, dual agent, or designated agent. You only fill in the agent's names here if it is a designated agency situation. Designated agency is one broker, two agents, and each agent has a client relationship with their party. So one broker, one agent is working with the buyer who signed a buyer brokerage agreement, so they're a client. One broker, the other agent has the listing agreement signed by the seller, so they're working with the seller as a client. In that situation, you write out the agent's names, because that is a designated agency situation. If it is two different firms, you don't put the agent's names here. The agent's names will appear on the signature page. And then material relationship. That is a relationship between the agent or broker and the buyer or seller. I encourage you, obviously, a family relationship or a business relationship is a material relationship. I encourage you to consider that a past client, if you're working with a past client, that is also a material relationship. All right. Now, moving on, the next section of the purchase and sale agreement, what time is it? Is further explanations of what has gone on for the fill in the blanks. When you guys are presenting your offers to your buyers to construct an offer, or to your sellers to present an offer, don't skip the rest. Don't just cover a paragraph, the first page of the contract. I highly encourage you guys to go over and make sure that your public people understand what it is that they are promising to do and the consequences of what they agree to do should the party fail to perform. As a point of practice, when you first working with a buyer or first working with a seller, I encourage you guys to pull out a blank purchase and sale agreement, write sample across it, because you don't want to give them one to fill out on their own. That's a GAR licensing violation. But give that to them, ask them to review it, so that when they get a written offer, or if you're working with a buyer, when you write an offer, they'll be more familiar with the terms and it's not such a crunch situation. All right, I'm going to go through all of this section. Let me show you guys where it is I'm talking about. So in the purchase and sale agreement, GAR for this year has added the phrase further explanations to the corresponding paragraphs. And we are just going to go through what is going on with what title is being, just all of these paragraphs. Again, not line by line, because we've got a lot to cover, but I just want to point out some salient points to you. We're going to go through the purchase and sale agreement and the counter offer form, and then we're going to take a break. So hang with me. And again, these slides and the handouts with all my underlines are available to you. And let me put that information here. I'm going to put that information in the chat where it is available, so you guys can write that down. All right. Come on. There we go. So the title that is being conveyed is called good and marketable. That just means it's insured by the title company at regular rates. There's not an exorbitant or an additional premium amount, just like any insurance where you have to pay a premium. It's regular rate that the title company charges to insure the title. It is by limited warranty deed. And also it has in this paragraph that a buyer must assume any leases. So you buyer's agents, if you guys are buying a property that has been leased out, regardless of what the seller says, regardless if the seller says, well, that tenant's lease is up prior to closing or simultaneous with closing, so forth and so on. If the tenant does not vacate that property, you are buying that property with that lease intact. And should you close on that property and the tenant fail to vacate, number one, you're going to want to have a copy of that security deposit. And if that tenant is in default of their lease, you as the buyer who would be the new owner is going to have to go through with the eviction process to evict that tenant. If there is something going on with the title, the buyer has the obligation to send notice to the seller. And again, you guys will hear that mostly from the closing attorney. You as an agent will get an email from the closing attorney that says something about there's a cloud on title or a lien on title, something like that. Per the contract, however, the buyer then, a lot of times what happens is you agents will try to deal with it agent to agent via email, but the contract requires that the buyer send written notice of what's going on with the title, an objection to the title. The seller has so much time frame to cure, which is by closing or any unilateral extension thereof. And then the buyer has termination rights to protect their earnest money. That's all spelled out here under the examination of title. Closing date and extension. If the contract fails to close on the closing date, which again can be amended a number of times, as long as the buyer and seller agree via amendment and they both sign it, you can extend a closing date for however long they want to do that. However, it can only be extended unilaterally. Uni is the prefix that means one. And the easy way to remember that is like a unicycle, only has one wheel. So unilaterally means you only need one party's signature, and they can extend the contract for 8 days as long as they send notice to the other party before the day of closing. All right, before I get to that, we've got a question. Wife and I are agents. If I was the listing agent, she was the buyer's agent, would that be dual agency? No, if you guys are both with the same brokerage and you have a listing agreement or seller brokerage agreement signed with the seller, and your wife has a buyer brokerage agreement signed with the buyer, that is not dual agency, that is designated agency, because there's two agents involved, one broker client relationship, but two agents. And the easy way to think of that, all contracts belong to the broker and are in the name of the broker. So the easy way to think of that is the broker has a buyer client and a seller client. The broker has quote unquote designated you, Donald, to work with the seller, and the broker has designated your wife to work with the buyer. That's actually where the term comes from. Dual agency would be one broker, you as the agent, and you have signed a listing agreement with the seller and a buyer brokerage agreement with the buyer. One broker, one agent with a client relationship with both sides. That's dual agency. Even with designated agency, y'all need to check with your broker's policy. Dual agency is not illegal as long as it is disclosed and the parties give their consent in writing. All right, back to the 8-day unilateral extension. It is the closing date gets extended 8 days from the last day of closing, not 8 days from when the notice is given. And there are only very, very specific reasons what if they work with a team, it's still different agents representing the parties. You have to be very, very, very careful and check with your broker's policies, but I would encourage you to disclose that and get both. I would technically that's a good question. Technically that's not dual agency, that is designated agency. But I would proceed with the public as if it were dual agency, meaning make sure that you get their consent, their written consent, and that both buyer and seller understand that the agents with whom they're working are different agents, but on a team. Okay, back to the unilateral extension. It is only for certain reasons. Only if there is a valid title objection, but only if it's a cloud on title. If the title there's a lien on the title, if it can be paid off with money or a bond, you may not use the 8-day unilateral extension. If the mortgage lender, if the loan is tied up in underwriting and the mortgage lender cannot fulfill their respective duties or has not sent out the TRID disclosures, you can use the 8-day unilateral. If the closing attorney has not finished their duties via title search or can't get you scheduled, you can use the 8-day unilateral disclosure. It can only be used one time per contract, not one time per party, but one time per contract. Why do I have never scheduled a closing on a Friday? When is 8 days not really 8 days? It only happens when you are scheduled to close on a Friday, because 8 days from Friday is a Saturday. You cannot close on a Saturday. There is no banking on a Saturday. Now, a lot of banks are open on Saturdays for consumer convenience, but there is no banking on a Saturday. There's no money federally changing hands. And in the purchase and sale agreement, paragraph C4F, it says no time deadline shall be extended by virtue of it falling on a Saturday or Sunday or federal holiday, except for the date of closing. What that means, if your due diligence ends on a Saturday, it ends on a Saturday. If your financing contingency ends on a Sunday or federal holiday, it ends on a Sunday or federal holiday. However, if for whatever reason the closing date, either you have not looked at a calendar or 8 days from a Friday is a Saturday. So if there's an 8-day unilateral extension, the closing date by virtue of this paragraph automatically gets extended to the next business day. So 8 days from a Friday would be a Saturday. Can't close on Saturday. Next day would be a Sunday. Can't close on Sunday. The next day would be a Monday. That's 10 days. If that Monday is a federal holiday, that would be a Tuesday. So there could be a time when the contract is staying intact and you're holding one of the parties in contract against their will for 11 days. That's going to cause a lot of issues.
Against their will.
I say against their will because if they all agree to it, then you would extend the contract via amendment where they all agree. So it's against their will because it's unilateral. You're only going to use the unilateral as a last chance, a last ditch effort to keep the contract together, because it can only be used one time per contract. All right, under the closing term, closing attorney, you're going to put the law firm, not the closing attorney, because attorneys change firms. And if it's a specific closing attorney that's not actually conducting the closing, you're still in contract. Nobody's breached it because it's the law firm. Again, the closing attorney represents the mortgage lender if there's a loan. If not, it says that the buyer shall choose the closing attorney. And it says the closing attorney shall represent the buyer. Don't let your buyer clients misunderstand that. That doesn't mean that they have legal representation if there's a contract dispute. It just means that with respect to the contract, the closing attorney represents, in other words, prepares the documents in light of the buyer's position with respect to the contract. It's way above and beyond what we really need to cover. Just the important thing is that your public buyers don't feel that they've got legal representation in a dispute. I don't know of any attorney that's going to represent a client in a dispute without a fee. All right, holder of the earnest money. Again, the buyer and seller negotiate when the buyer is supposed to send the earnest money to the holder, but there's a lot of other information going on here. It says the earnest money will be paid to the holder. Remember, they in paragraph A, you check, ACH, wire, so forth and so on. But new in 2022, GAR has added that the holder has the right to charge the buyer for any costs associated with receiving earnest money. In other words, let's say there is a fee to receive a wire. The holder can charge the holder can charge the buyer that fee on top of the earnest money, and it has to be separate. The holder, once they receive it, they have 5 banking days after the binding agreement date to actually deposit the money. So there's a time frame for the buyer to send the money that the buyer and seller negotiate, and then pre-printed, the holder has 5 banking days after binding agreement or from when it's received to actually deposit the money. The holder does not have to act on the money until it has cleared the account. And if it does not clear the account, so in other words, it also says back here, sorry, it says that the holder, somewhere in here, I'm sorry, I can't find it, but it says that the holder can approve the form of the earnest money. Like I said, buyer and seller can agree to an ACH, but if the holder doesn't approve of an ACH, the holder can say, no, you need a different form of the earnest money. If the buyer never sends the earnest money, or if the holder deposits it and it bounces from the bank or is not honored by the bank, at that point, the holder is required to send notice to the buyer and the seller that they have not received the earnest money. You guys, this purchase and sale agreement is a receipt from the holder that they have received it. A lot of closing attorneys don't act on this part of the contract. If they never get it or it bounces from the bank, they are required to send notice to the parties that they don't have the money. Then the buyer has 3 banking days to cure that default. If not, then the seller has 7 days to terminate. There's a lot of times a seller would want those termination rights, especially if a buyer hasn't sent in earnest money, to go on to another contract. Again, you guys as agents, y'all need to follow up with the deposit of the earnest money. If the seller does not terminate, then the contract continues. Again, earnest money is not required for enforceability for a contract for real property in Georgia. You just need to make sure that the lender knows and the closing attorney knows. Then what happens to the earnest money? Well, this is all described in paragraph B7, the earnest money. Who's entitled to it? How does it get dispersed? What's an interpleader agreement, and the hold harmless language. If there's no issues, then the buyer gets the earnest money. If it never, they get the earnest money back. If it never goes under contract, or if there's not a contingency isn't met, there's a termination agreement signed, and the seller agrees to give the earnest money back, or if the seller terminates by default, or upon closing, it gets credited towards their closing. Also in that paragraph, it states that there must be written agreement signed by the buyer and the seller directing the holder how to disperse the earnest money. Again, we call that TNR, which stands for termination and release, even though the actual document itself says unilateral notice to terminate and proposed agreement to disperse the earnest money. It only takes one party's signature to terminate a contract. So a buyer can terminate or a seller can terminate. Once it's terminated, it's terminated. The issue is what happens to the earnest money. Well, that is a separate issue, even though GAR addresses a termination and the earnest money on one form, GAR F522. But there must be agreement per the contract and actually per license law in order for the holder to disperse those funds. And the parties can agree to divvy up the funds. It can be 100% to one party, 50-50, 70-30, so forth and so on. Now, what happens if a contract fails to close, but they don't agree on what happens to the earnest money? They don't sign the release portion of the earnest money. Well, then the holder gets to do, and this is all again addressed in this paragraph B7. The holder can interpret the contract and write what we call the 10-day letter. In other words, the holder goes back through the contract, finds out why, does their research, figures out why it didn't close, and then they send a notice to the buyer and the seller saying, I intend to disperse the earnest money in this manner. In other words, yes, the buyer sent notice of termination prior to the expiration of a contingency. For whatever reason, the seller didn't sign it. Or no, the buyer signed the termination before the end of that contingency time frame, but they didn't send it until after the contingency was over. So the buyer defaulted. But regardless, the holder sends this 10-day letter of their intent to disperse the earnest money. The holder has to wait at least 10 days to get a written objection from the other party. That's why it's called the 10-day letter. These funds are tied up during this time frame. So if you have a buyer, let's say you have a buyer, they terminated and you sent notice of termination to the seller before the end of the due diligence period. If the seller does not sign the agreement to release the earnest money, the holder must still go through this 10-day letter process. If your buyer finds another property they want to buy, that second seller is also more than likely going to want earnest money. You cannot use the earnest money that's already on hold for a second contract. It is not available during this time frame. It is tied up. If the earnest money is too much or the situation is too legally convoluted, or if it is an all-cash transaction and the closing attorney is the holder, it must go to court. There is a lawsuit that gets filed between the buyer and the seller, and the holder does what's called interplead the money, and it goes to court and a judge decides. The holder gets to take out their legal fees and court costs from the earnest money. And as I mentioned earlier, the judge may award legal fees that the loser has to pay the winner's legal fees. Or the earnest money can be dispersed by a court order. Hold harmless means the buyer and seller agree not to sue the holder for their decision. All right, going on with due diligence. This says that this is all spelled out in paragraph B8, where we talk about inspection and due diligence, duty to inspect neighborhood, warranty transfer, property sold as is, and repairs. Due diligence, again, we've had a long discussion about that, is a buyer's option to terminate the contract with no penalty. You must not only sign the termination notice, but send it to the seller prior to the expiration. Seller has a legal obligation to disclose late material defects, which we have already discussed. You, as an agent holding a license in the state of Georgia, have a duty via your license to also disclose any known defects with the property, even if your seller asks you not to disclose it. You cannot keep that confidence per your license. Again, Georgia is a caveat emptor state. We've talked about all of this. And during the course of an inspection, a buyer may ask a seller to address certain concerns with the property. A buyer can always ask a seller to address certain concerns, even if the seller says they're buying it as is. Doesn't hurt to ask, right? And you would do this on an amendment to address concerns with the property. Let me cover that quickly while we are on that section right here, because this is the notice to unilaterally extend closing. And again, it spells out those reasons. Okay, amendment to address concerns with the property, only to be used during a due diligence period. You guys, this is the only amendment in the GAR contract package that has a time limit on it. What do I mean by that? Well, it says this amendment is intended to set forth the agreement of the parties relative to concerns raised by the buyer during the due diligence period. If this amendment does not become effective during the due diligence period, and effective means if buyer and seller don't both sign it before the end of the due diligence period, it shall become null and void and of no legal force and effect. In other words, if a buyer sends a seller things on this amendment to address concerns, it says seller to repair reverse polarity and GFCI outlet, seller to repair and replace and repaint damaged wood around the windowsill, so forth and so on, seller to replace roof. If the buyer sends the seller this amendment, but the seller does not agree to it, and we're coming up to the end of the due diligence period, either your sellers agree, if they go past the due diligence period, the buyer has agreed to buy the property as is, or they need to terminate and send notice of termination before the end of the due diligence period. Let's say buyer sends this amendment to the seller doesn't sign it, due diligence, but it's not anything major. The buyer's going to go through with it anyway. It's just that they'd like for the seller to address those concerns. They send it to the seller, due diligence period comes and goes, passes. We're the next day after due diligence. The buyer has not terminated. If the seller signs this amendment saying they agree to replace the rotten wood, repaint the rotten wood, reverse the polarity, this amendment, if it is signed and sent back after the end of due diligence period, no longer exists. So buyers, you cannot hold sellers to what they have agreed to on this amendment if it was not signed prior to the end of due diligence period. You will need to do a new amendment, a general amendment addressing those concerns. Again, this is the only amendment with a time limit that coincides with the due diligence period. All right. Question: what if the buyer terminates before the number of days to submit earnest money? Great question. If earnest money is addressed in the, let me see if I have this. Remember slide 41. I believe I have this addressed here. I may have taken it off. Okay. If earnest money is, I'm sorry if I'm making y'all dizzy. Here we go. I'll just go ahead and cover these anyway. When you tell a buyer an earnest money is safe because they have a due diligence period, again, if the seller does not sign that TNR, their earnest money is tied up. Also, if it's a personal check, the holder might hold on to it. Talked about that Proof of deposit, talked about that. Again, if it's in dispute, it's not available. All right. Talked about that, Okay, here you go. If earnest money is addressed in the creation of a contract, it must also be addressed in the termination of a contract, regardless if the buyer has sent it or not. Your buyers are not off the hook, free and clear, protected if they terminate by default. Well, either by default or for a contingent within a contingency, if they terminate before they have sent the earnest money to the holder. So if a buyer is terminating a contract prior to the expiration of a contingency before they have sent the earnest money, then on the release portion of the TNR, you simply write buyer to retain earnest money not yet remitted per paragraph A7B. If the buyer is terminating a contract and they are in default, but they have not yet sent the earnest money. If they, remember I told you the holder has a certain time frame that they have to deposit it. If not, they, or it bounces from the bank or they haven't received it, then they have to send notice. If there is a situation where a buyer terminates by default, they have not yet sent the earnest money, but the holder has not yet been contractually obligated to have sent notice that they haven't received it, then unfortunately the burden is on the seller to legally pursue that earnest money from the buyer. So that's a different situation. But in answer to your question, if the buyer is terminating via a contingency before they have sent it, then this is what you write in the release portion. Buyer to retain earnest money not yet remitted per paragraph A7B. All right, let's go back. A due diligence period may only be extended by an amendment. There's no unilateral extension of a due diligence period. And then I have a point of practice in here for you guys. What should you write if a seller hasn't done something? Let's say that the utilities aren't on, or the seller has not sent a completed community association disclosure. Well, what you first think is you would write a special stipulation that would say something like due diligence to begin when buyer turns on utilities. No, because guess what? If the buyer never turns on the utilities, if the seller never turns on the utilities, your buyer never has termination rights. If your buyer terminates, but due diligence hasn't started until then, your buyer's going to be in default. So you never want to write that due diligence to start upon an issue being corrected. What you would write a special stipulation. You're going to know this when you show the property. For example, utilities aren't on, or like I said, seller hasn't provided the completed community association disclosure. You're going to write a special stipulation that says due diligence to begin upon binding agreement date and extend for whatever number of days, 10 days, 3 days, 2 days, whatever, after buyer's receipt of written notice of utilities being on and operational, or after written receipt of seller's completed community association disclosure. That way, your buyer's due diligence starts as soon as you go under contract. So if the seller never turns on the utilities, your buyer can go ahead and terminate, protect their earnest money, and go on with another property. No, you don't have to write this if there's not an issue. This is just if there is an issue, like utilities aren't on, and so it can't be inspected or it can't be appraised. If everything is fine, then the due diligence period begins upon binding agreement date and extends for X number of days per that paragraph in the contract. All right, repairs. What about repairs? Repairs tend to be an issue. The GAR contract simply states, I'll show you guys where it states that. Oh, going back to right here at the bottom, paragraph 8E, repairs. All agreed upon repairs and replacements shall be conducted in a good and workmanlike manner prior to closing. Point of practice, if buyer and seller negotiate for repairs, y'all probably want to add a special stipulation that those are to be completed a certain number of days prior to closing to work through any issue, rather than at the walkthrough prior to closing what's going on. Again, what if the seller doesn't do repairs? Can a buyer terminate without defaulting? Can a buyer close and sue the seller for contract breach? There is no clear answer. It would be up to a judge. Unless you add it in as a special stipulation, there are no automatic termination rights for a buyer if the seller doesn't do repairs, and repair issues don't automatically survive closing. So this is a huge issue. If you guys are negotiating for a seller to actually complete repairs, you need to address potential issues of a seller's non-performance when you are negotiating for repairs. You either want to put that the seller's obligation to do those shall survive closing, or better yet, it's always preferable to handle repair issues financially if at all possible. And a fabulous special stipulation to use would be seller to pay the vendor at closing from the seller's proceeds. The money goes directly from the seller to the vendor, so it's not going to impact the buyer's loan. It's not going to be counted as a seller's contribution to the buyer's loan. So the special stipulation would be at closing from seller's proceeds, seller to pay whatever vendor, Roofs R Us, X amount of dollars. Then the buyer is in possession of the check payable to the vendor and can schedule the work themselves. Or a seller can escrow funds to take care of the repairs. Or we have a lot of special stipulations authored for us by closing attorneys and in the GAR special stipulations to address repairs. With any special stipulation, you guys, please check with your own broker before using in any contract. Here is one of them that talks about repairs need to be completed a certain number of days prior to closing, all work completed by vendors, licensed, so forth and so on. Here's what happens. Should seller not complete work required herein at least 5 days in advance, either the buyer can hire vendors at the seller's expense or has termination rights to recover their earnest money. Here's one in the RE forms contract package that talks about escrowing money. So there are all sorts of ways to address repairs, but the time to address a seller not doing repairs is when you agree to do them on that amendment. Moving on to brokerage relationships, as I mentioned, you must disclose an agency relationship. We talked about how a public is a client. They must sign a brokerage agreement for our Beretta laws. If the public buyer or seller is a customer, there is no law that requires them to sign anything. Your broker may have a policy on that, and as a point of practice, it's always a good idea for you as an agent to have them sign a document that describes the customer relationship. The seller would sign the authorization to show unlisted property, GAR F-107, and the buyer would sign the agreement to work with buyer as a customer. That describes the customer relationship. Here's the slide I was looking for. Dual agency, one broker, one agent with a client relationship with both. Designated agency, one broker, two agents, each with a client relationship with the public. You can have both sides. You need to check with your broker's policies, but you can have both sides of a deal without it being a dual agency situation. It's not dual agency if you have a client relationship with one, a customer relationship with the other, or a customer relationship with both, but it can be tricky. And I highly suggest you get consent from both parties in writing to protect you and your broker and the parties. Tons of consumer brochures I always suggest that you guys use when appropriate. Again, with the going on with the brokerage relationships, it does say that commission is earned by the broker, but the amount of the commission that is earned is pursuant to another agreement where it says pursuant to a separate brokerage agreement. That does reference the buyer brokerage agreement or the seller brokerage agreement. In addition, you guys are also going to complete the instructions to closing attorney that is signed by the seller's broker and the buyer's broker. But those agreements for the public to pay the broker's commission is agreed to in the brokerage agreement or in the authorization to show unlisted property. The instructions to closing attorney is not an agreement between the public and the broker. It's an agreement between the two brokers. So what document describes how you as the agent get paid? What document gets signed where it spells out how much you as the agent are getting paid in a transaction? Type it in the chat. What document describes what how much you get paid for any one transaction? Type it in the chat, everyone. Listing agreement. Listing agreement. Listing agreement. What else? What are some other ideas? Where it describes where you get paid. Instructions closing attorney. Nope. Nobody's hit it yet. D8. Nope. 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 Buyer brokerage. Nope. Buyer broker. Nope. This is how you as the agent, how do you get paid? How much do you know how much you're getting paid for any one transaction? Commission agreement? Nope. I stumped y'all.
Tell her it's been a long time.
Nope. 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 All right, I'm going to tell y'all. I just want to make sure y'all are awake. Agreement between brokers? Nope. Exclusive brokerage? Nope. You guys, how? Okay, let me phrase it another way. This will direct your thinking. What is one of the things you look at when you are choosing a brokerage with which to hang your license? What's one of the things that you consider when choosing a brokerage?
The percentage. Yes,
there we go. Yes, broker support, but how much you're going to get paid, your split, your commission split. The document that describes how you as the agent get paid is spelled out in your independent contractor agreement that you sign with your broker. Remember what I said. This is true. You guys, all contracts are done in the name of your broker. So in a listing agreement or seller brokerage agreement, your public seller agrees to pay your broker X amount of dollars commission. In a buyer brokerage agreement, your public buyer agrees to pay your broker X amount of dollars. In the instructions to closing attorney, the seller's broker agrees to pay the buyer's broker. Thank y'all very much for making me a lot of money. However, that has nothing to do with you as the agent. The only way that you as the agent know how much you are getting paid for any transaction you do is what you have agreed upon with your broker in your independent contractor agreement. And a lot of agents will choose a broker. There's a lot of things. There's broker support, there's training, there's education, there's location, there's systems, there's services, there's fees, there's opportunities, there's leads, there's blah, blah, blah. But one of the main things that you look at is how much are you going to get paid of the broker's commission per any transaction. Do you split that with a broker? Do you just have to pay your broker a small transaction fee? So forth and so on. So that is described in your independent contractor agreement. Even a split between two agents, that's not between two agents, you guys. That's between the brokers. All those agreements are in the name of the broker. All right, moving along. Again, this is all spelled out in the Ooh, we got a lot to cover. I didn't realize there was so much. I guess I did realize there's so much. I just talked too much. And that's all the earnest money. We've talked about all that. I'm back on the contract. Under this brokerage section here, where it talks about the brokerage and the disclaimer and all that information. This is all that what I'm addressing here in the slides. It is all spelled out and underlined. What are the brokers or agent signature? Are they required? No. Your broker signature or your agent signature on a purchase and sale agreement is not required for enforceability of the agreement between the buyer and the seller. So what does it mean when you do sign it? It means it just affirms the agency relationship that you indicated on the front page. If you said your broker has a client relationship with the seller, when you sign it, you are an affiliated licensee with your broker. So that means your broker has given you permission to engage in that client relationship with the public. Additionally, if your broker is the holder of the earnest money and you sign the contract and your broker has given you permission to sign a contract on their behalf, that states that, yes, I will fulfill all the responsibilities of holder of earnest money as outlined in the contract. However, that being said, there are some lenders that will require an agent or broker signature on the contract to sell a loan. So is it required for enforceability? No. But is it a good idea? Yes. But let's say there's an amendment and it's signed by the buyer and the seller, but one of the agents won't sign it. It's still enforceable. All right, this disclaimer section. This is very, very important. This protects you as an agent, and it protects your brokers. And basically this is where it talks about the special stipulations too. Basically what all that says is, and again, I just encourage you guys, nothing is an issue until it's an issue. If you've taken my classes before, you've heard me say that numerous times. Parties have not relied on agent advice. Buyer needs to check out anything that is important. Seller needs to seek independent information regarding their position per the contract. Parties understand that the special stipulations were written for their behalf. Buyer acknowledges that the answers to the questions are from information from the seller. Contract tip, I encourage you guys, if the buyer says, for example, what's going on with the neighborhood, or better yet, has anybody died in the house? I highly suggest that you've got to really start thinking, especially you agents who've been in practice for a long time. You need to get everything in writing and protect yourself, protect yourself, protect yourself. I highly encourage you. GAR has a form, F325, Broker's Information Disclosure, that has a place where you fill in the question and fill in the answer and you write the source of the answer. But the purchase and sale agreement, it states that all answers to questions are from information from the seller. All right, time limit of offer. This states that the offer, it is not, a lot of agents mistakenly think that this is a time frame for a party or an agent to respond to an offer, or this is in a counter offer too. No, it is only a time frame for the receiving party to accept with no changes, to accept the offer with no changes and send notice of acceptance to form a binding contract. So if a party is going to make a counter offer, then the time limit is of no consequence. In other words, if a buyer writes an offer to a seller and they put a time limit on it of 2 o'clock today, if the seller makes a counter offer, a seller can make a counter offer before 2 o'clock, at 6 o'clock tonight, at 11 o'clock tonight, tomorrow, 2 days from now. The time limit has nothing to do with anything if the seller is going to make a counter offer. These terms are only open for acceptance with no change for that time. After that time frame, if the time limit is 2 o'clock today, then after that time frame, it's pulled off the shelf. It's no longer available for acceptance. You go to a store to buy the latest pair of tennis shoes. Guess what? They are on sale for, let's say they're normally I don't know, let's say they're normally a $500 pair of tennis shoes. They are on sale today for $100, but only until 2 o'clock. After 2 o'clock, they are pulled from the shelf. They're no longer available to purchase. So that's what a time limit is in essence. So what happens what happens if a party signs an offer after a time limit? So let's say the buyer writes an offer and it has a time limit on it of 2 o'clock today. Let's say the seller loves it, doesn't make any changes and signs it, but they don't sign it and send it back until 6 o'clock tonight. Do you have a binding contract? The answer is no, you do not have a binding contract. You have a counter offer because the offer was no longer open for acceptance after 2 o'clock. So the seller in essence made a counter offer. So the buyer would then have to sign it and send it back. If there's no time limit, then the party making the offer, you must remember to withdraw the offer or counter offer to take it off of the table. That would be a notice to withdraw offer or counter offer, not the notice to reject an offer or counter offer. The notice to withdraw an offer is the party that made the offer is pulling it off the table. The notice to reject an offer is the party that received an offer saying, I'm not taking it. Whew, what time is it? I have a little bit more to cover than, all right, 9:30. Let's take a break. I thought I was going to finish with the purchase and sale, but I'm not. We are on the notice section, but it has been, we are going on 2 hours. So let's take a break. What do you think? Y'all ready for a break? I see a lot of head nods. All right. It is 11:15. Let's take a break. Let's come back at 11:30 and I'm going to talk a little bit faster. Back from the break. Please go ahead and once again type in your name, email address, license number. But we are going to take a break and come back at 11:30. All right. If there are any questions, I will take those at this time. If not, we will continue on. I've got a lot to cover. I'm going to talk a little bit more quickly, believe it or not. And I will stay afterwards to answer as many questions as possible. Again, it is great to see everybody. And all right. We're going to continue on. So I'm going to go back to sharing my screen. And we're going to finish up the purchase and sale agreement. The other documents don't take as long, but obviously the course is GAR Contract Dissection. So the majority of the class is the purchase and sale agreement. So we are going to continue on and we will finish up. So all right, let me get that out of the way. And we are on the purchase and sale agreement. Let me show you guys where we are. We are on the notice section, which is paragraph C1. So we're going to finish all this section, the other provisions, definitions, and then we'll finish up with the purchase and sale. Sorry if I'm making you all dizzy. Let me go back to where we are here. Notice. So let me go back to the PowerPoint. And again, I do have everything covered in the PowerPoint and the PDF slides are available to you. A PDF of the slides. Okay. This notices section, basically what this says is notices must be done in writing, signed by the buyer or seller, maybe delivered in person, or delivery by certified or registered U.S. mail, or delivery, I have delivery, but it means a delivery company like a courier, overnight delivery service, U.S. mail, fax, or email. You'll notice there is nothing about phone calls. Therefore, no text message. Notice by a text is not recognized as meeting the terms of notice in the GAR contract, because a text message is sent via phone, which is not addressed. Now, this is important, you guys. This is notice by electronic service, which is email. That's the majority of the way you guys do business, by email. is deemed received. Deemed is just a fancy word that means believed. So notice is considered received. An email is considered received when the sender can prove they sent it, regardless if the receiver opens the email or not. So what that means is this is important when you're coming to example, terminating a contract and sending the termination notice. Let's say your due diligence period expires tonight. Well, the day goes through 11:59 p.m. tonight. So let's say that I've gotten a termination notice signed by my buyer, and my due diligence period, the buyer's due diligence period expires tonight at 11:59. If I send it via email at 11:58 p.m. tonight, then even though the receiver doesn't receive it until 11:59 or doesn't even open it until tomorrow, the buyer has still met the terms of that contingency, because the email notice is deemed received when the sender can prove they sent it, regardless if that party opens it or not. But it must be emailed or faxed or sent to the address that is on the signature page of the purchase and sale agreement. So you guys, when you are completing a purchase and sale agreement, make sure that the email address or fax number is a place where you are doing business. So if your company, and a lot of times the contract forms through Remine or whatever auto-populate some of that information. If your contract forms auto-populate, for example, your broker's fax number, and somebody sends a notice to you on Friday evening at 6 o'clock, chances are you aren't going to get it until Monday when staff comes back in town. So if that's not how you're going to do business, take out the fax number from the from the signature page of your agreement. You only need one of those three forms of notice, either email or fax or a mailing address. If your contract, if the signature page auto-populates with an email address that, for example, your company gave you, but that's not really how you're doing business, then change that to the email address that you're doing business, because notices must be sent to the contact information on the signature page of the contract. As I mentioned earlier, if you have a client relationship with the public, then notice to the broker or to the staff at the brokerage is considered notice to the party. Unless it's a dual agency or designated agency situation, then it must go to the agent. If it is a customer relationship, then notice you're still going to contact the agent and the broker, but you must send notice to the buyer or seller directly if they are a customer. So again, that contact information for that public customer must also be on the contract. Again, email or fax or address, but does not have to be if you're representing the public as a client. Now, what happens if one of the parties defaults? Well, if the buyer defaults on the contract, then the seller's sole remedy, when doing an email, wouldn't it be advisable to do a blind copy or a carbon copy to yourself? And if you mean to yourself, yes, I think that would be a great idea to make sure it goes out. Also, especially you guys in this environment right now with multiple offers and time sensitive issues, it's always a good idea professionally, just for protection as a courtesy, you can send a text to a co-op agent as a means of professionally making sure stuff's done. For example, if you send an offer, you might want to text or email the agent saying, hey, I just want to make sure you received my offer. I sent it, blah, 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 this time, so forth and so on. Because sometimes there's a lot of mail. I get regular email from agents all the time. And then every now and then, for whatever reason, that same agent's email will go to my spam folder or junk folder. So you can use email for professionally communicating with another agent, but it does not hold up in terms of the parties serving notice to each other. But yes, great idea, Ed, to send to copy yourself or send a blind copy. especially let's say you're sending an email from a different computer or from a phone or from, Remind or something like that, one of these electronic services, and you just want to make sure it goes through. Great point of practice. Okay, if a buyer defaults, the only remedy for the seller is the earnest money. A seller, let's say a seller has moved out and hired moving trucks and blah, 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 and the buyer defaults. The seller has agreed when they went under contract with the buyer that they're not going to sue them for moving expenses or, time in a hotel, so forth and so on. The only thing they agree they can receive is the earnest money as liquidated damages. Now, what happens if a seller defaults? Well, the buyer has one of two options. The buyer can either send a termination notice and get their earnest money back and go find another house, or they can sue the seller for specific performance. If they choose to sue the seller for specific performance, they don't get their earnest money back because it's another lawsuit. A judge decides it's not money. It's a judge making this seller go through with the contract. So if it goes to court and a judge rules in favor of the buyer, then the earnest money is still part of the deal. So if a seller defaults and the buyer is going to pursue a lawsuit for specific performance, they don't get their earnest money back. I have no idea. Different counties, there's going to be a different length of time that is going to be before that lawsuit is ever heard. So there's a lot more involved in that. If that is going to be a buyer remedy. Now, what about the broker? The broker may pursue a defaulting party for the commission they would have earned had the contract closed. Again, the parties have agreed when they sign the purchase and sale agreement that they are not going to, it says may not do, but it's supposed to be sue. They have agreed to not sue each other for damages, expenses, costs incurred, emotional distress, so forth and so on. And if there is a lawsuit, now don't get me wrong, you guys, anybody can sue anyone for anything. But the other party's attorney, if they're savvy, is going to say, look, when you went under contract with this party, you agreed that the default for a breach is so forth and so on. If there is a lawsuit, the loser may also have to pay the winner's legal fees and expenses. All right, moving on. What happens if there's damage to the property? Well, the contract states that at closing, the property is to be in substantially the same condition at closing as it was as of the offer date, including whatever items are staying. It's supposed to be clean and free of trash, debris, and items not negotiated to stay with the property. If there is substantial damage, for example, damage by weather or major vandalism, the seller is required to send notice to the buyer, and then either party may terminate, or if they don't terminate, the seller has the option of repairing it, and then the parties close. That has to be done within 1 year, or they must close within 14 days after notice that the contract has been repaired. All right, there's a thing that says entire agreement. Basically, it says once it's binding, it may only be changed in writing signed by the parties. That would be amendments and termination. If it's going to be terminated, it must be done in writing. And let me talk just a little bit about terminating a contract. The majority of clients will choose to terminate a contract by a unilateral notice of termination. And that is this form. Again, we refer to this as a TNR. The R stands for release of earnest money, because that's what it used to be called, but now it's called unilateral notice to terminate and proposed disbursement of earnest money. I've already gone over this a little bit, but again, you only need one party's signature to terminate. That's why it says or. However, per license law and per the contract, you need both parties' agreement as to what happens with the earnest money. That's why it says and. If a party is terminating, you fill in the reason. And again, if it's due diligence, you just write due diligence. You don't need to give a specific reason. If a party terminates unilaterally, then once they sign this and send it, it's terminated. There is a mutual agreement to terminate. This form, in essence, acts as an out-of-court settlement agreement. That's if there is a dispute or one of the parties is going to terminate. Both buyer and seller, it says it's a mutual agreement to terminate. So everybody has to sign it. This is where, especially if a party is going to terminate and there might be a default, this is where both parties agree to terminate. You describe what happens to the earnest money, but also you describe if any of the parties is going to compensate one of the brokers rather than one of the brokers having to pursue them legally for default. So you put the amount of money that a seller or a buyer is going to pay to the buyer's broker. Buyer or seller is going to pay the buyer's broker or the seller's broker. What happens to the earnest money between the parties? And this does require buyer signatures, seller signatures, and broker signatures. Now, again, this is a great way to terminate that acts as an out-of-court settlement agreement. However, when you are coming up against the end of your contingency timeframes, you don't necessarily want to use this. Let's say a buyer, let's say it's today, and I'm working with the buyer, and the buyer's due diligence period ends at 11:59 p.m. tonight. I am not going to have my buyer send this and sign it and send it at 11:58 tonight, because what happens is if it is not signed by all four parties, buyer, seller, and both broker/agents, it is not terminated. So if you are coming up against the end of a contingency time frame, you're going to want to use the unilateral to protect earnest money, because this does not terminate with one signature like the unilateral does. So I just wanted to bring that to your attention. All right. Assignment. For those of you working with investors, the GAR purchase and sale agreement is not assignable in and of itself. The seller must agree in writing for it to be assigned. So if you are working with, if you're a buyer's agent working with an investor who you know is going to assign it to another party, you are going to want to include this special stipulation, which is brand new in 2022. Special stipulation 611. It says seller consents to buyer assigning this agreement to another buyer and having assignee become the buyer thereunder. Then there is a separate agreement, which is GAR F279. That is an agreement between the assignor and the assignee. In other words, buyer number one and buyer number two. It is not part of, the seller doesn't sign that. Extension of deadlines. I've already talked about that when we talked about the 8-day unilateral. There's a paragraph that says no authority to bind. Basically what this means is you are the real estate agent, basically advising if you have a client relationship or performing ministerial acts if you don't, but filling out the contract and going through things from a real estate perspective. You, by virtue of your signature, do not have the authority to bind the party to terms. In other words, whatever you tell another agent is not, your public person is not bound to that. However, you may fill in the binding agreement date. Now, there's been a whole bunch of, for whatever reason, there's a lot of questions about the binding agreement date. And in 2022, GAR has sought to address those with some new verbiage and some new paragraphs. So let me just show you quickly where all of this is in the purchase and sale agreement. Again, this is under the other provisions. There is, it talks about the binding agreement date in terms of notice of binding agreement date, what happens if there is a dispute, so forth and so on. There is a brand new paragraph, objection to binding agreement date. There is a brand new form F733, which is an amendment to confirm the binding agreement date. So let me just quickly talk about that. Let me go back to, where'd the slideshow go? Here we go. All right. So basically, in those paragraphs, it says if there is a dispute over the binding agreement date, it may be resolved by court or by written agreement between the buyer and seller, or by the holder of the earnest money in resolving a dispute having to disperse earnest money. If you get a contract and you fill in the binding agreement date, the party accepts it as basically, okay, let me back up. Notice of binding agreement date. The accepting party sends notice of binding of acceptance to the offering party. If you're using the offer or counter offer form, okay, I'm confusing myself. The binding agreement date is basically the date that there is notice of acceptance. So if you have, let's say the buyer writes an offer to the seller and the seller signs it, you do not have a binding contract at that point. You have an accepted contract, but the seller has not yet sent notice of that acceptance back to the buyer. It is only binding when the seller, in my example, sends notice of acceptance to the buyer, then the buyer binds it, and that's the binding agreement date. So the party, the easiest way to remember this is the party that made the last offer or counter offer is the party that binds the contract. A down and dirty way to look at this is if you're using the GAR forms and the name initiating the form auto populates on the bottom of the contract. For example, I'm using training forms, but you know, oh, it doesn't even have it here. On the bottom of your purchase and sale agreements, it has a place here where it has the name of the party that's initiating the form. Basically, that would be the party making the last offer or counter offer, and they're the ones that bind the contract. Oh, there I have it there. Forms. The agent whose name is pre-printed on the bottom, generally speaking, would be the party that binds the contract. So just because you have a contract that has all parties' signatures, that's an accepted contract, but not necessarily binding. Once you send notice of acceptance to the party that made the last offer or counter offer, that's what creates a binding contract. And just FYI, that date is day 0 for counting all the contingency timeframes. So what happens if there is an objection to the binding agreement date? Let's say you receive a contract back and you fill in the binding agreement date, or you receive it back and it has the incorrect binding agreement date filled in. Well, there's a new paragraph, C4K, objection to binding agreement date. And basically what that says is if you receive, so, okay, basically what this says, the party has 1 day to object. If you don't object, resolving it in writing, which you would use this new GAR form F733 binding agreement date, then whatever was on there is the new binding agreement date. So in my example, let's say buyer sends an offer to a seller, seller signs it. Let's say that all happens today, what's the date? Today is April 6th. So let's say buyer sends an offer to the seller signs it on April 6th, but the seller does not send it back to the buyer, and obviously through the agents, until tomorrow, April 7th. So the seller has signed the contract on April 6th. They send it back to the buyer's agent on April 7th. What is the binding agreement date of the contract? Type it in the chat. No changes. Yes. The 7th. The actual binding agreement date is the 7th because that's when the seller sent notice of acceptance to the buyer. Okay, no problems. However, what happens if the seller gets the offer today, the seller signs it today on the 6th, let's say they send it back to their agent or they do it themselves, they fill in the binding agreement date on the bottom of the purchase and sale agreement as the 6th, because that's when they signed it. But then they send it back to the buyer tomorrow, the 7th. So now the buyer's agent has received a fully executed signed contract They receive it on the 7th. The seller or the seller's agent sent it on the 7th. But when they receive it, the binding agreement date on the purchase and sale agreement right here has the 6th filled in. What's the binding agreement date? Yes, no, it's not the 6th. It is still the 7th. The binding agreement date is defined as notice of acceptance. So it's the 7th. However, you have a contract that has the 6th written in here. What do? Well, this new paragraph in GAR states, this is new paragraph K, states that you as the buyer's agent, you now have 1 day to say, no, that binding agreement date on the purchase and sale agreement is incorrect. The binding agreement date is not the 6th, it is the 7th. And what you would do is you would use this new form. If I can find the new form. I can't find it right now, but it's a new form, F733, and it states binding confirmation of binding agreement date. You would put on the 7th. You buyer's agents, if the actual binding agreement date is the 7th, but you get a signed contract back and that the binding agreement date here is filled out as the 6th. If you have, back here to this new paragraph, you have 1 day to make an objection. If you do not make that objection, then the binding agreement date is the 6th. This is going to be an issue if your buyer terminates on the last day of a contingency, because now if you do not lobby an objection, the new binding agreement date is the 6th, even though per the terms of notice, it was the 7th. So you don't want to lose out on your buyer's earnest money thinking it's the 7th if you don't lobby an objection. So that's brand new this year that you guys really, really need to pay attention to. All right, this next section, it talks about rules for interpreting. This is another new paragraph, C4I, rules for interpreting this agreement. And basically what this says, this is not new as far as the hierarchy of contracts go. This is brand new paragraph K, rules for interpreting this agreement. This is not new in and of itself. It is new in that they have put it here under this part of the purchase and sale agreement, but this verbiage used to be after the part about exhibits and amendments. And basically, what you have is the terms of the purchase and sale agreement pre-printed first. That any handwritten changes shall control or supersede or take precedence over pre-printed or typed provisions. Any exhibits shall control over the main body of the purchase and sale agreement. Any special stipulations will control over both exhibits and the main body of the purchase and sale agreement. That's why I said at the very beginning, you never want to write a special stipulation that addresses something already addressed in the contract or in an exhibit. So for example, if you have a buyer and they're getting a loan and there is an appraisal contingency in the loan, you never would want to write a special stipulation that says property must appraise for sale price, because the special stipulation supersedes over the exhibit and you have just now negated everything in that exhibit. Well, what happens if it doesn't? Are there termination rights? What happens to the earnest money? You did not write any of that. So you never want to write a stip that addresses something already addressed in the contract. However, this has always been the case, but GAR has spelled it out. It says in subparagraph C4J4, this little part right here, notwithstanding the above, any amendatory clause in an FHA or VA exhibit shall control over inconsistent or conflicting provisions contained in a special stipulation or exhibit. What is all of that about? Well, the amendatory clause is basically the appraisal clause for an FHA or a VA exhibit. And what that says, I'm going to cover the loan contingency exhibits in a minute, but let me just show you while I'm here, because this is really, really important in our market right now. This is the FHA exhibit. Paragraph 11 is the amendatory clause, which is the appraisal, in essence, the appraisal contingency. Basically, it says the buyer shall not be obligated to complete the purchase of the property or incur any penalty by forfeiture of earnest money if the property appraises for less than whatever the sale price is. It says the buyer has the privilege and option to proceed, but they can terminate and they'll get their earnest money back. Same thing, and this is the VA exhibit, amendatory clause. Buyer shall not incur any penalty by forfeiture of earnest money or be obligated to complete the purchase if the property does not appraise for reasonable value as established by the VA. So what that means is that the amendatory clause is a government regulation, a federal regulation. Therefore, I don't care what appraisal gap stipulation the buyer and seller have agreed to in a contract. If the buyer is getting an FHA insured loan or a VA insured loan, even if there is an appraisal gap stipulation in the purchase and sale agreement, if the property appraises for less than sale price, the buyer may send notice of termination to the seller prior to the closing date, and they will get their earnest money back. So you listing agents, it's trickeration. It's just a ploy. It is not enforceable. If the buyer is getting an FHA or VA or USDA loan, a government insured loan, if there is an appraisal gap stipulation, pretend like it's not there, because it is not enforceable. A buyer can't just not show up to closing. They have to send notice of termination. But if the buyer sends notice of termination prior to closing, they will get their earnest money back regardless of an appraisal gap stipulation. All right, survival of agreement. Basically, the parties' obligations that legally continue after closing. Commission, they're obligated to pay a commission. The title, the warranty of title survives closing. All written representations of the seller regarding the property or the neighborhood. If the property's been condemned, attorney's fees are going to survive closing. The obligation to pay property taxes survives closing, and any obligations which the parties agree to survive closing. That's why I always encourage you guys to use the magic phrase, this provision shall survive closing. So for example, if a seller agrees to purchase a home warranty for a buyer and it doesn't get done or paid for on the closing statement, then if when you guys wrote a special stipulation that says at closing seller to pay 1-year home warranty for the buyer not to exceed blah, 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 to be paid for by seller. If you did not write this provision shall survive closing and you close and that home warranty did not get ordered, then the seller is no longer legally obligated to pay for that for the buyer. So that's what that is about. All right, further on in the purchase and sale agreement, there is a section on definitions. GAR has added in this year a banking day. A banking day in the GAR contract is defined as Monday through Friday, no federal holidays. Again, banks are open on Saturdays for consumer convenience, but there is no money changing hands federally. The binding agreement day, we've talked about that. That is defined in the definition section. Broker, anytime the contract uses the word broker, it means the qualifying broker the actual brokerage or the firm, and you, the affiliated licensee. It goes on to say a business day is defined the same thing as a banking day, Monday through Friday, no federal holidays. If it just says day, that is a calendar day that runs through 11:59 p.m. Further on or earlier on in the purchase and sale agreement, it does say that the time frames go through are related to Georgia. Whatever the time frame is in Georgia is what the time frames refer to in the contract. Material relationship, we've already talked about that. Cyber fraud, you guys, huge issue in our industry for you as agents, brokers, mortgage lenders, and closing attorneys. You definitely want to have a conversation with especially your buyers, but your sellers too, when they're sending payoff information or wire instructions for one closing attorney to send proceeds to another closing attorney for a back-to-back closing. Never, ever trust wire instructions via email. It is the emails that are getting hacked, as well as text messages. You will never tell your public people, they will never get emailed wire instructions or text wire instructions. And as I mentioned, a lot of your closing attorneys are no longer even using the encrypted wire instructions. Most of them are sending out via US mail or handing out in person. Your public people should cross-check and verify with a third party like Google. Don't trust a phone number or an email address that comes over email with wire instructions. You guys as an agent should never, ever share wire instructions from the closing attorney or from your broker with the public. Let the public person get them directly from the closing attorney. And again, that would be electronically. Never email. You should have a wire fraud disclaimer on your email signature. You can give them to them by hand. It's just the emails and the text messages that are getting hacked. There is a section in the GAR contract about limit of broker's liability. It says it's liability, either the commission that was paid, if no commission was paid, $100, or it does say limit to $100 for any loss of funds through wire or cyber fraud. I do not believe this paragraph in GAR has been tested in the courts, so I would not necessarily rely on that 100%. Again, exhibits supersede purchase and sale. That language used to be here under exhibits and addenda. They've moved that to that new paragraph. And signatures and binding agreement date. Again, we must have all buyer and seller signatures, include license number, firm license number, mailing address, again, for a closing attorney or purposes of notice. And I've talked about this. If the public's a customer, you must include their either address or email or fax. Talked about all that. Woo! All right. Believe it or not, we have finished with the purchase and sale agreement. All right. Woo, okay. I really want to cover the financing contingencies. So on the counteroffer form, basically the original offer is incorporated, and you only need to sign the actual counteroffer. As I mentioned at the beginning, if there is a counteroffer, but you are not countering something from the original offer, you're going to write in NC for no change rather than NA. And here's what I'm talking about. Here's the counteroffer form where it says purchase price. If the parties are keeping the purchase price, you're not going to put NA because it's obviously applicable. You're just going to put NC, which means no change. All right, let's move on to the financing. Oh, here's where I have all that information. All right. Let's talk about financing. I'm going to talk about the financing contingency exhibits because those can be a bit tricky. And I have all of these slides here, but I'm going to go through the contracts themselves. Again, I'm going to put in the chat where you guys can access and download these handouts after class. It is not only the forms underlined, but it is a PDF of all of my slides. But instead of bouncing back and forth like I have been doing, I'm just going to show you guys on the actual forms. I think it's easier for you guys to kind of get in context where it is, and I'm going to talk through it, and it's all underlined. You're welcome. All right. Conventional loan exhibit. Again, fill in the blanks, all that kind of stuff. You guys know how to do that. License law says if you're making a contract subject to financing, you are required by license law to fill this information in. Use of a particular mortgage lender. This is not obligating your buyer to use that lender. However, if your buyer is going to terminate under financing, the loan denial letter must be from whichever lender or one of the lenders, if you're using more than one, that is identified here. So you buyer's agents, it's best to leave that blank. You seller's agents, you're probably going to want to know specifically a mortgage lender if to protect your seller's interest should a buyer terminate. Again, the buyer, and you're going to fill out all this information. All of this information that you fill out is really regarding termination of a contract based on a buyer not being able to convince a lender to lend them the money based on this loan. A buyer, it says right here, the buyer may apply for a different loan. Buyer can come to closing with any means that they can to purchase the house. They can get this loan described here. They can get a different loan. They can come with cash, so forth and so on. However, if a buyer is going to terminate and protect their earnest money based on the financing contingency, they must terminate within, so under here, paragraph 5, they must terminate within so many days from the binding agreement date, and they must prove it with a loan denial letter. The loan denial letter, however, has some strings attached. If they're going to terminate, if the seller says, okay, buyer, you have so many days from binding agreement date to convince a lender to lend you the money. If you're not going to do that, you have to terminate the contract with me and you have to prove it. You prove it with the loan denial letter. However, the loan denial letter must be a denial of this loan described up here. And it must be from one of the lenders identified here if that was the case. If not, it has to be a denial letter from a lender licensed to do business in Georgia. But if you're not going to terminate and you're going to go through with the deal and buy my house, you can do so with any means necessary. However, I'm the seller. If I agree to go under contract with you and you're going to tell me you're going to go pursue a conventional loan, that's fine. You do not have the right, this is paragraph here, paragraph 3, what I'm going through now. You do not have the right to get an FHA or VA or USDA loan unless I, as the seller, agree. Why? Well, because if you're going to get an FHA, VA, or USDA loan, we're going to need to do a different contingency that's going to get rid of the conventional loan contingency and go with that. The reason is, if you get a government insured loan, that incurs costs to me as the seller because there's certain fees I have to pay based on one of those loans, number one. Number two, if my property is appraised by an FHA or VA lender, that appraisal value sticks with my property for an FHA or VA loan for a certain period of time. I am not agreeing to that unless I agree to that in writing. So that's what's spelled out there. Then it goes on to say more about the loan denial letter. Okay, so not only does the loan denial letter have to be a denial of the loan described in what we filled out here, and from one of those approved mortgage lenders, if one was named, it has to be very, very specific. And what it cannot be based on is in this little paragraph here. If the lender denies you the loan, but the reason they are denying you the loan is because you don't have the money for your down payment or closing costs, well, this is the proverbial adding insult to injury or salt on the wound. Not only are you not going to get the loan, but you are also going to lose your earnest money because you do not meet the terms of this financing contingency if the loan denial letter is based solely on Paragraph 6A, buyer lacking sufficient funds other than the amount to close the loan. In other words, no down payment or no closing costs. B, if you haven't sold or leased other real property and we didn't agree to that as a separate contingency. C, if you did not provide the lender with the documents they required in a timely fashion. D, if you made purchases that adversely affect your credit score. In other words, the lender pulled your credit and it showed this score, and then you went and bought a whole house full of furniture and your credit ratios are now messed up. Well, no, you're not going to get the loan, but you're also going to lose your earnest money because you do not meet the terms of this financing contingency because that was based on your actions. E, the property not appraising for at least the purchase price unless it is subject to an appraisal contingency. They put this in there this year because of this market that we're in. A lot of buyers were writing an offer to a seller and they were putting in no appraisal contingency, thinking that they could protect their earnest money by getting a termination of financing under the financing contingency exhibit and protect their earnest money. No, 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 no. A financing contingency and an appraisal contingency are two completely separate issues, even though GAR handles those both on one form. A financing contingency means it is an assessment of a lender. It's a lender saying of the person, and it is a risk assessment of the lender assessing, is the person, I'm going to lend money to this person. How confident am I that they're going to pay me back? That's what a financing contingency is. It is contingent upon a seller convincing a lender that they are going to pay them back. It's not a big risk. I'm going to pay you back. I'm going to borrow hundreds of thousands of dollars and I'm going to pay you back. Here's how I prove I'm going to pay you back: with my credit score, with blah, 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 with the money I've got, blah, 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 blah. A financing contingency is an assessment of the person's risk to pay them back. However, your lenders are like, okay, let's say I make a gamble on this person and I'm pretty confident they're going to pay me back. But just in case they don't pay me back, I will need the buyer to put up something for collateral. Well, the collateral is going to be the house. So the lender's going to say, okay, I'm going to take a risk on you paying me back. But if I made a bad decision and you don't pay me back, I'm going to hedge my bet and I'm going to take the house back so that I can sell the house and I will at least recover the amount that I was going to lend you. So I'll recover my losses one way or the other. So an appraisal contingency is an assessment of the value of the collateral should the lender have made a bad decision in lending the party the money. But a financing contingency is an assessment of the person's ability to pay back. The appraisal contingency is the property. So they are two completely separate things. And then back to this loan denial letter. This is brand new this year. And you buyer's agents, this is really, really, really tricky. It says if the lender did not complete the underwriting loan request and your buyer has to terminate, your buyer's going to lose their earnest money. This is putting a lot of pressure on your buyers. Your buyers need to be really, really careful about the lenders they choose to do business with and make sure the lender's going to get the job done. If the lender doesn't get the job done and it ends up terminating or closing outside of like an 8-day unilateral extension, buyer's going to lose their earnest money. All right. This section about seller's request of evidence of a buyer's ability to close. Basically, what this says is the financing contingency timeframe has passed. The buyer didn't terminate. Then the seller can request a loan commitment letter from the. Thank you. A loan commitment letter from the lender. I'm not going to go through this a lot because the timeframes. This looks good on paper to try and give the seller some confidence that it is going to go through. You guys have all had enough experience. Nothing is a done deal until your commission check has cleared the bank. Until it's funded, it is not closed, regardless of any, especially any lender letters. But the time for it, this looks good on paper, but the time frames a lot of times don't work out. But there are seller termination rights if you've gone past the financing contingency time frame, you request a loan commitment letter and you don't get it. Appraisal contingency. All right, let me cover this quickly. All right, I'm still good on time. Basically, this is the conventional loan. This is the GAR conventional loan exhibit. And basically this says buyer and seller agree that they're going to go under contract, but the property must appraise for the sale price of the property. And again, this is a lender just saying, in case I made a bad decision on the buyer, my belief that the buyer's going to pay me back, I need to make sure the collateral that I'm going to get back is going to be enough where I can sell it and recoup my losses that I lent the buyer. So there are so many days from the binding agreement date where I can make sure that the collateral is worth that value. If not, if the appraiser appraised the property less than the sale price, and that's all tied into the sale price because the sale price is the figure that the lender is using, a percentage of that to lend the money on. If not, in the GAR contract, the buyer is obligated to give the seller the option to sell the property for the lower price. So what this says, this number of days that you fill in paragraph 11, this is not a time frame for a buyer to terminate on a low appraisal. This is merely the time frame to start this process. This is merely the time frame. If the property appraises for less than sale price, the buyer has so many days from binding agreement date to send the seller a copy of the low appraisal plus the amendment to the sale price to give the seller the opportunity to sell it for the lower price. Now, the seller then has 3 days from getting this amendment to say, yeah, I'll sell it for that, or nope, you went under contract with me for the higher sale price. I will not accept a penny less. If the seller says yes, then you sign to the new with the new sale price and you go on to closing. If the seller says nope, I'm not agreeing to a lower price, there is nothing that obligates a seller to sell for a lower sale price, including an appraisal gap stipulation. That is just an obligation. An appraisal gap stipulation is just a buyer stating that they agree to bring additional cash to the table on top of their down payment, prepaids, and escrows should the appraisal come in low. But it's not an obligation for the seller to sell for less than sale price. But anyway, back to this appraisal contingency in the exhibit. If the seller, so the buyer has so many days from binding agreement date to send the seller an amendment to the sale price along with a copy of the appraisal. The seller then has 3 days to say, yep, I'll sell it for that, or nope, not doing it. Then the buyer has an additional 3 days to decide if they're going to terminate and get their earnest money back, or a buyer, even if you do not use this appraisal gap stipulation that's so prevalent right now, a buyer always has the opportunity to bring additional cash to the closing table to buy the house for the contract price. So all of that is spelled out in this contingency time frame. So again, a lot of buyers mistakenly think that this time frame that you fill in the fill in the blank is a time frame to terminate. Under the conventional loan in GAR is just a time frame to start that process. All right, FHA. Everything is the same that we've talked about, including the loan denial letter. However, it doesn't say anything about the appraisal. We've already talked about this. The amendatory clause is the appraisal stipulation for an FHA insured loan. There's no time frame on here, meaning a buyer has through contractual day of closing to send notice of termination to a seller and protect their earnest money. The difference between an FHA insured loan and a VA insured loan, the buyers do not have to give the seller the opportunity to sell it lower. They can immediately terminate and get their earnest money back. Now they can bring cash for the difference, and they can see if a seller will negotiate for a lower price. But in an FHA and VA insured loan, they are not obligated to do that. All of that is spelled out here in the amendatory clause paragraph. Further on, again, remember I told you that in an FHA and VA insured loan, the seller incurs fees that they don't in a conventional loan. Here's where that is spelled out. Tax service fees in an FHA loan. In a VA loan, it's tax service fees plus a termite letter. And an FHA or VA insured loan, the appraisal may require some repairs be done, and those repairs would need to be done prior to closing. Buyer and seller negotiate for that amount that the seller agrees to pay. And if the amount of actual repairs is more than that, this paragraph talks about how you work through those and how, if you can't work through those repair issues, termination rights and what happens to the earnest money. VA loan exhibit is just like the FHA loan exhibit, a mandatory clause. However, the VA funding fee, a veteran has a funding fee, and typically that is added into the loan amount. It talks about repairs, again, paid by the seller. It talks about a termite letter, and any termite damage must be paid for by the seller and repaired by the seller. So those are additional costs for that. On the all cash exhibit, basically it says all cash or no financing contingency. So this is the exhibit you're going to use if a buyer is actually paying cash, or if a buyer is getting what's called a hard money loan, meaning it's not going through an institution, not going through a mortgage broker or a bank. It's a short-term, high-interest loan that some buyers get, especially a lot of times if they're an investor and they're going to flip the property or so forth and so on, they'll get a hard money loan. Or look at this. This also says that a buyer does have the right to actually get a first mortgage from a mortgage lender or a bank, but they're just not making their contract contingent upon that. So it's not necessarily all cash. So there is a section about verification of funds. There is an appraisal contingency that the parties may or may not agree to using an all cash exhibit. Community Association Disclosure Exhibit, GAR for 2022. You guys hang with me, we're almost done. GAR for 2022 has changed this to be more consistent with all the other forms. All the other blanks have been moved to all the fill in the blanks have been moved to paragraph A, and all of the further explanations have been moved to paragraph B. And in the other thing that they have done is they've added for 2022, they've added this section, buyer's use of disclosure. Again, as I mentioned, Georgia is a caveat emptor state. The burden is on the buyer to check out everything regarding a property before they buy it, including what is required if the property is part of a community association. Now, the seller is required to disclose all the fees. Basically, what all of this information has, the seller is required to disclose if there is an association, if there is a management company, the contact information, any assessments, the transfer, initiation, and admin fees, utility expenses, what's covered, so forth and so on. The rest of this information, in essence, states if a seller does not disclose the fees, or if the fees are higher than what the seller has disclosed, at closing, the seller is required to pay those fees, even if they're buyer fees. This is not designed to punish or penalize a seller. It's just that what's going on with homeowners associations and management companies right now is they will only give this information to the current seller. They won't give it to buyers, and they won't even give it to agents. So it is just a way to get sellers to get this information. But there's nothing about the covenants and conditions and restrictions. So in this instructions on how to use, The buyer is still responsible for finding the covenants of the HOA, and those are available as a recorded document in the county of where the property is. And it also obligates the seller to update the information if any changes have been made. So again, you'll want to look through all of this information. And GAR has also changed it to, it used to be just initials. They've added actual signature lines there. We've talked about these exhibits with closing attorney and the holding earnest money. We've talked about this amendment to address concerns. We've talked about when a party can send a unilateral notice to extend the closing for 8 days. And again, we've talked about that. That's just the form you use. We've talked about the TNR. And guess what, you guys? Believe it or not, we have actually made it. These slides have all the information that I have covered. Let me talk about some amendments to address concerns. We've talked about that. Notice we've talked about that. I think we made it. We talked about earnest money and termination. Woohoo. I talked fast, talked a lot, but I believe I made it. I will stay on and answer any questions. Again, please confirm all contract questions with your broker. We do have a lot of additional courses. All virtual class credits will be recorded within 3 to 5 business days. Before you leave, once more time, please type in your name, email address, or real estate license number and phone number in case we have questions. I do have a YouTube channel, Real Estate Made Crystal Clear, where I cover all of this stuff, as well as the RE forms, license law, some lead generation tips, more in depth. And the target audience of my channel are all real estate agents in the state of Georgia. So I encourage you guys to go check that out. I hope you guys, this was the proverbial drinking water from the fire hose, but I hoped you guys all learned something, got a glance of the 2022 GAR contracts. And I am everything is going really quickly. Once everybody finishes putting in their information, I will put once again where you guys can access the handouts, which is a PDF version of these slides, as well as all of the forms underlined. And again, I hope everybody has a joyous and prosperous and healthy year, helping others with their real estate needs with the blessing of your real estate license. And I thank you guys so much. And again, I will stay on for any questions. If you want to unmute yourself and ask a question, feel free to do so, but please mute yourself back so everyone can hear the answer. I would say type it in the chat, but it's going by very quickly because of everybody typing in their contact information. If you have to go, thank you guys so much. And I look forward to seeing you guys in another class, but I'll stay on to answer any questions.
Hello.
Hello.
Yes, I have a question to how can I get into the chat that you mentioned to put my email and my license number?
So at the bottom of your screen, do you see a little icon that says chat?
No, I don't see any button.
All
This
right,
meeting
any
is
other
being
contract
recorded.
questions?
Yes, Dana, this is Deborah Miller.
Hi, Deborah.
Hi, new construction contracts. Now, I haven't been doing real estate for a little while now, but my daughter was telling me that a friend of hers did a new construction contract. They signed it, and then the builder came back and said, well, it's going to cost me more than I thought. And he was adding that to the contract.
Yep.
He can do that even though they have a signed contract?
We are seeing that a lot with new construction, and there are a couple of issues going on there. Number one, you have to read the contract. Every contract is different. For example, the 8-day unilateral extension, that's not Georgia law or anything. That's just in the GAR contract. That's not a right to unilaterally extend any contract. The parties have to agree to that. So with respect, Deborah, to a new construction contract and a seller, a builder, raising the price, you're going to have to go through and read that entire contract verbatim and see if that's in there. A lot of times we're having the costs have increased, or for whatever reason, we are having a lot of builders that are proposing an amendment to the buyer, splitting the costs or whatever, where a buyer and the builder or seller agree to the increase in costs to go through with the contract. Again, it could be already agreed upon in the terms of the new construction contract. You'll have to read it and see what provisions the buyer has already agreed to. And we are having some builder sellers that are just terminating a contract and going in default, and they're taking their chances of being sued by a buyer. You'd have to look at the remedies for default in that contract. Again, you guys, everything is contractually driven. So in a new construction contract, should a seller default, you'd have to see what the buyer's remedies are. Does the buyer have the right to sue for specific performance? Is that a Georgia law or is that a contract law? Can a buyer sue them for actual damages? Don't get me wrong, anybody can sue anybody for anything. It's whether it's going to hold up and be what a judge is going to say for anything, even in the GAR contract. But you know, some sellers are like, you know what, I'm going to take my chances. Even if I get sued, I can make, number one, I can make more money by selling it on today's market, or if it's not built yet, I simply cannot afford the materials required to complete the property. The construction package, the framing package is more than I've got to do right now. So even if a buyer sues me for specific performance, I can't perform. I can't sell a house. I can't build if I don't have the money. So lots and lots of going on with those kinds of situations, but I can't comment on that with respect to the contract, because you'd have to read that specific contract that the buyer and seller signed and what they had agreed to.
Yeah, and that's where a good agent comes into play too, to make sure that contract has been read over. The agent has read it over. But anyway, okay.
As I've said, nothing's an issue until it's an issue.
Exactly. Thank you.
Yes, ma'am.
Bye-bye. I really enjoyed your class.
Thank you, Ms. Miller. I appreciate that.
Now, I'm taking another contract class. Are you going to be teaching that too?
I don't know what is it. I teach a bunch. I teach the contracts review where we talk about GAR and RE. I teach RE.
Okay, that's the next one I'm taking. I believe contract review.
Yeah, I don't know. We've got a lot of instructors through the Georgia Real Estate Academy that teach a lot of our contracts classes.
Oh, okay.
So it should say on the registration. All right. Any other contract questions? Yes, sir.
Thank you for taking the class, first of all. I was not on camera. I'm not expecting C credits because I'm more than 15 credits over. I was in this class to listen in and see what I'm missing from the new contracts. So one question is, in my market, more and more sellers are going for temporary occupancy, and they just don't accept the contract if there is no temporary occupancy. And we are putting the temporary occupancy exhibit as a part of the purchase and sale. The question is, does it have the language enough that the sellers will actually vacate the property?
Great question. So the temporary occupancy agreement, the GAR temporary occupancy agreement, a couple of things. Number one, it does not have, a lot of buyers would want compensation for the privilege of, for granting the seller the privilege of staying in the property for an extended period of time. And I know this market, buyers and sellers are agreeing to a whole variety of things, but generally speaking, per the form, the GAR temporary occupancy agreement does not have any sort of fee in there for that the seller now pays the buyer, who's the new owner, for the privilege of staying in the property. Not in there. There is a fee in there that they agree to, that is a per diem or a calculated per day should the seller not vacate the property when they say they're going to on this agreement. So, couple things. Number one, the temporary occupancy agreement should only be used if the seller is going to stay in the property for 60 days or less. If the seller is going to stay in the property that a buyer now owns more than 60 days, you really need an actual lease. And that's going to change the nature of the loan. The buyer then really should have gotten an investor loan versus an owner occupant loan. So the temporary occupancy agreement is in essence temporary occupancy, not a lease. The reason that you do not want a lease, especially if you're working on behalf of the buyer, you do not want a full-blown lease for temporary occupancy, because if you have a full-blown lease, the Georgia landlord tenant laws kick in. A whole nother body of laws kick in that really favor, in Georgia, really they favor a tenant more than the landlord. So that would then favor the seller who no longer owns the home, but who's occupying the home. That's why you don't really want a lease. How you want temporary occupancy, you want it for less than 60 days. However, if a seller does not vacate a property, they've agreed to a temporary occupancy agreement. They do not vacate the property when they said they were going to on that agreement. Number one, you have a contract dispute that can be litigated in either an arbitration or litigated in court. It's a contract dispute. It's not a lease dispute. That seller that is occupying the property is considered, the label is a tenant at sufferance. It's not a tenant as far as an actual lease, but the legal term for somebody occupying a property when they are no longer have written permission to do so is considered a tenant at sufferance. The buyer, who is now the new owner, still has to go through the eviction process. They're still going to have to go down to the magistrate's court. They're going to have to file a writ of dispossessory writ, so forth, and go through the eviction process to get rid of that tenant at sufferance. And I highly suggest they get an attorney, because again, you don't really have an actual lease. It's not a lease dispute, it's a contract dispute. But the process to get that owner to vacate, they're still going to have to go through the court system. And that would also get a judge to enforce that per diem that the tenant, the seller, who's now the tenant at sufferance, agreed to pay. Good luck getting it, but it could be enforced judicially.
Okay.
Now that brings up a good question, you guys. This has come up a lot recently. What happens if a seller, you go to closing, and let's say a seller has left either at time of closing, let's say possession was at time of closing, or even with the temporary occupancy. Let's say the person has left, but there are still some of their personal property items remaining in the property. Let's say the seller put everything in the garage, and for whatever reason, they couldn't move the stuff out of the garage. The buyer now takes possession. What happens to those personal property items? Do they now belong to the buyer? Can the buyer sell them? Can the buyer throw them away? Those items still legally belong to the seller, even though the buyer has possession. Your buyer who now owns the property, if there are still personal property items of the sellers that do not stay with the property, is going to have to probably get an attorney, because you might have to go through the eviction process for those items. A buyer who now owns the property does not automatically have the right to trash those personal property items or sell them. That could be considered theft by conversion, because they are not their belongings, even though they are in the property that they took possession of. That is a very potentially complicated legal issue that they will need legal advice on. But do not advise a buyer that takes possession with items still there that don't belong there, that they can do anything with them. That is not the case.
Miss Dana, I have a question. Would
Okay.
those items then be considered abandoned?
Nope, not necessarily. You
Okay.
you need a court order to figure out what to do with that stuff. Your buyers need to get an attorney and legal advice on what to do with that stuff. It is not necessarily considered abandoned property.
Okay, I had a question earlier about the counter offer. So
Okay.
when a contract is submitted and countered, you said the only form that needs to be signed is the counter offer form. So we don't have to sign the original contract?
Nope, you don't. You absolutely, a seller never goes back and signs the original contract because the counter offer form references that it is a counter offer to an original contract. So so the counter offer form, you're going to have one counter offer form that has both buyer and seller signatures on it.
Okay,
It references the original offer. So anybody that gets a hold of this signed counter offer knows to go back and look for another form. They know to go back to look for an original offer. If your buyer, so a buyer's going to sign an offer. If your seller signs a counter offer form and signs the original contract, in essence, you have two binding contracts because the original offer does not reference a counter offer. And if your seller signs that, then that could be considered the terms that the seller agreed to. You have two binding contracts.
okay,
Your seller never, ever, 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 if they agree to terms on a counter offer, seller never goes back and signs the original offer. Never, ever, ever.
okay,
So then you're thinking, well, what about our lenders that don't take these classes and they want a signed contract? If that's the situation, then what you're going to do is you're going to execute what's called a conformed contract. And in essence, what that means is you go back and you rewrite, you pull out a blank purchase and sale agreement, and you fill in the blanks that reflect the terms the parties agreed to via the counter offer. And I always suggest that there's a special stipulation 662 that says all parties agree this is a conformed or a clean copy of the contract. If there are any discrepancies, i.e. typographical errors or whatever errors from this copy and the terms of the original, then the terms of the original prevail. I also suggest you write at the very top of a conformed contract, clean copy, just so everybody knows.
okay. Thank you very much.
My pleasure.
I loved the class. I loved
Thank
it
you.
so much. It was great.
Awesome. Thank you so much.
Uh-huh.
Any other questions? Y'all just staying on to hear other people's questions? All right, everybody. Thank you guys so much. I appreciate your time and attention and wish you guys well. And I appreciate your taking the class. Bye, everybody.